Items for pronouncement of judgment. Item number 22, RFA 130 of 2018.
Impugn judgment can be placed set aside and cost, but it is a decree granting alternative relief.
Number 23, WPC 5428 of 2019.
Petition allowed.
Please, Your Lordship.
Yes,
Lordship, with the consent of the petitioner, Lordship, I beg to mention item 19, Lordship.
19.
Yes, Lordship. Lordship, here in this matter, Lordship, I have received some updated instruction. I'll be filing my affidavit on behalf of the respondent number 1.
Mr. Upamanya, learned standing counsel for the Higher Education Department, with consent from the other side, request for listening the matter after
10 days, Lordship.
10 days.
Well, can it be on, if you can, date a date can be fixed, my lord.
10 days. 29th.
So as to enable him to receive up to date instruction.
No, there is the interim order, madam. My interim order is there.
Interim order pass earlier shall complete.
Much highly.
May I please, Your Lordship? I beg to mention item number 21 for adjournment, Your Lordship.
21. Miss, your good name, please.
As the
Miss S. The learned counsel appearing on behalf of
petition. Oh, Anish Baruya.
N.S. Bormia, learned counsel for the petitioner. Press for with consent from the other side. Press for listening the matter after
Your Lordship, a date.
June, in the month of June. Okay. On 5th June.
Obliged. Consent
May I
of other side, I beg to mention item number 12 to 18, Lordship.
item number
12 to 18.
item number 20,
12 to 18, Lordship.
12 to 18. Is your good name?
J. Gogoi, Lordship.
A. Gogoi, learned counsel appearing on behalf of Mr.
BP Bora.
P.P. Bora, learned counsel for the petitioner. With consent from the other side, press for listening the matter after
2 weeks, Lordship.
2 weeks.
okay.
2 weeks.
May I please, your Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 9. Lordship, on the last occasion, Lordship has directed for some instruction to produce record. Lordship, the concerned officer is on medical leave. That's why, Lordship, I pray for 2 weeks time, Lordship, to produce them.
You inform the petitioner?
Yes, I have already informed yesterday, Lordship.
Okay. Mr. Soduri, learned standing counsel for the BTC.
SSA, Lordship, you do.
And BTC and SSA.
No, SSA.
Only SSA. Oh, SSA. With consent from the other side, press for listening the matter after 2 weeks. Parallel.
Obliged.
May it please, Your Lordship. Lordship, item number 24 and 25, Lordship. The matter was listed day before yesterday, and Your Lordship was pleased to indicate that matter will be taken up at 2. So there is no indication. Lordship is taking up at 2 or prior to that?
Prior to that, if possible.
Lordship, obliged.
Petition matters, item 1, part heard.
May Lordship. Lordship, I may allow to 1 week time, Lordship, file a reply petition against the affidavit. Lordship. It's the last.
You will not file your reply.
Yes, Lordship.
Mr. Arcedas, learned counsel for the petitioner. Press for granting him 1 more week time to file reply to the affidavit in opposition filed by respondent number
3. Elementary.
respondent number 3.
3, Lordship. So this is the part heart matter, Lordship.
List the matter as part.
Yes, Master Lordship. No, date kindly fix, Lordship.
Part heard admission matter. On 21st May.
Yes, Lordship.
Item 2.
May it please, Your Lordship. Your Lordship, it's a 2020 matter. The petitioner was an assistant school teacher in Borbora Tea Estate LP School, Your Lordship. But he has been working since 2007 to 2011. So suddenly in 2011, he has been ousted from his service under some apprehension that there can be some labor union agitation against him, since according to them, his service was not according to appointment procedure. But without making any inquiry, without showing him any notice, he was outwardly ousted from service. Then he approached the Assistant Labor Commissioner for this matter, and after getting some directions from the Assistant Labor Commissioner, he was reinstated in service in 2018. That is annexure to Your Lordship. But again, after some 1 month, he was again ousted from his service. Then he again approached the Assistant Labor Commissioner, who directed the managing committee to consider his matter, but till date, nothing has happened. And what happened is that, Your Lordship, during his service was kept in abeyance, there was a notification by the state government regarding provincialization of services of the school teachers of Dhensar School. That was in 2017. As my services were kept in abeyance, I could not apply for taking the benefit of the government notification, Your Lordship.
Yes, Mr. Sharma, you have called?
Lordship, I'm appear for the respondent number 6 and 8, the Tea Garden Authority, Lordship. And the thing is that, Lordship, in this case, this school is run by the management. So, Lordship, the come to the order dated 24, then only 2 teachers were appointed by the government,
Deployed.
the school elementary education authority, Lordship. And they submitted that she doesn't come under that. The petition doesn't come under that. So court first, Lordship, you know, come to the order dated 22/4/2024. And
22/4.
22/4/2024, you know. And thereafter, after discussing all this issue, then court passed the order 35/2000 first to 22/4/2024. None appears for the petitioner on call. PK for learned constitutional elementary education department has placed on record the instruction is received by him from the director of elementary education, which reveals the school of the petitioner was provincial by order dated so and so. How it is contended that in the said instruction that the petitioner he is not entitled for being considered for provincialization of service as he was working as Shiksha Karmi under particular scheme, not teacher of the said school. However, in absence of counsel of petitioner, this court would not like to further consider the issue today, although list this matter on so and 35. Copies of the communication dated 21/4/2004 and notification dated as produced by Bora Learning Training Council Elementary Education Department is kept in record as marked as X and Y. Then you come to the order date 3/5/2024. He said, as some learned counsel for petitioner, in view of the stand as taken by the state of the present proceeding, she has granted 2 weeks time to file additional affidavit. Petitioners are now required to also satisfy the court as to whether the present writ petition being with regard to grievances raised against the tea garden would be maintainable. Because High Court here, the school is run by the management. So writ Supreme Court decision is there. On that ground, I challenge that writ petition is not maintainable. And now she is claiming that through government process, elementary education process, she is entitled. Then the court asks to file additional affidavit in opposition to the government. Last occasion, that is, so that was not, but documents all have been annexed and submitted. 9. The order is, you know, this order, you know, is of 25/9/2024. So so many annexes, if before that also come to affidavit in reply.
So, madam, you have filed your affidavit in reply.
Your Honor, so far his contention is that I was a Shiksha Karmi. I have filed my affidavit in reply. Since as they were filing the affidavit in opposition, that is filed on 28/6/2024.
Hmm.
My service of Shiksha Karmi was additional to my service of assistant teacher, Your Lordship. I was not only a Shiksha Karmi. That service was rendered by me under an
No,
agreement.
whether that appointment letter is available here. Your appointment letter.
Yeah, Your Lordship. Yes, Your, that is Annexure 3.
Annexure 3.
In 2018, though earlier appointment letter is unable to produce, but after getting the Labor Commissioner instruction, he was appointed in 2018, Your Lordship.
Appointment as assistant teacher.
Yes,
Annexure
Your
3.
Lordship. Annexure 2, Your Lordship, sorry, pardon, Annexure 2 of main petition.
So the school was being run by the tea company.
Yes.
It was a venture school, Your Lordship, that's why it is provisionalized
Hmm.
under the
Teach-
Provisionalized
yes.
Act of 2017. And that is according to the RTI report also.
No.
The school is provisionalized because it was a venture school.
That had already been decided by this school. Two teachers are provincial through that part. School is one, but two teachers are taken up by the government elementary education. They paid their salary. Rest is run by the management. So that's why court various opportunity was given to her to place that whether writ petition is maintainable or no. That's why X and Y kindly that document can see where it is has been clearly mentioned. What happened, Your Honor? Initially,
Yeah.
this, you know,
Your Lordship, kindly see Annexure B, page number 52.
in her read petition, kindly, if come to page number 15, annexure 3, you will come to understand that part. Page number 50,
Your Lordship, in
you,
Your Lordship,
No,
in
let her
page
submit.
page number 52, that is the RTI report by Block Elementary Education Officer that its school is provisionalized, Your Lordship.
No, there's a annexures are mismatched. Mismatched. Paginations are also not
So,
correct.
I think that page number 57 comes up. Annexure B, page number 57,
57 and 54.
Page number 57, the document is here.
Yes.
Here below, kindly say, this is in one, B. Barua LP school is provisional school. It is provisional by notification so and so. And four, the status of Barbara TLP active with enrollment 198 deployed teacher 2 and TG teacher 2 deployed 2 teacher only. Or the name of the teacher, that list is also been given. The another, by the way, how she is entitled for claiming relief from the elementary education put up the also by
No,
another list given
Mr.
the name.
Sharma, you are not the counsel for elementary education.
No, Joseph, because my only submission, that's why I'm placing that affidavit in opposition was also to be submitted by the elementary court passed that order 22/9/2024. The court said ask that let them file the affidavit that they have not filed that part. Only that is the part. They have to file the affidavit before the court.
Yes.
That is only the thing.
Your Lordship, the affidavit was only to bring 2 documents into notice.
No, your affidavit is all right, but their affidavit is not available.
10 days time may be granted, I will file it. Our stand will be the same date as all of that and
Same as?
same as which I have placed the document, my lord.
Hmm.
The recorded is annexed P X and Y.
Hmm.
Document.
No, if the school belongs to the tea garden, how can the service of two teachers can be provincialized by the respondent?
Actually, there's the meeting with the secretary and the department, and the department, they are, as per their state meeting, there are for about 200 something schools provincials, which is falls under the tea garden. Arranged by the tea garden. There is for only two folks were provincial. As decided by the.
Whether any policy decision was taken by the government in that regard?
I'll bring on this by filing and affidavit.
Okay. Heard, miss, your good name, please?
As Sharma.
S. Sharma, learned counsel for the petitioner, and Mr. Sharma for
Sharma.
respondent number
6 and 8.
6 and 8, and Mr. P.K. Bora for respondent number
1 p.m.
1, 2, 3. And Madam Info? Respondent number 5 and 7. And you? Okay. Heard in part, it is pointed out that the respondent number so and so have not yet filed their affidavit in opposition. Then Mr. Bora, learned standing counsel for the aforementioned authorities, submits that he may be granted 10 days time to file the affidavit in opposition. Here is accordingly allowed. Places the list of matter on 23rd May as part third.
Obliged.
Bless you.
Item 3.
Please, your lordship. Lordship, in this matter, the honorable court has already indicated on 2 occasions that no further adjournments would be granted. So I am humbly praying that the lordship may take it up for final disposal today. my lord. I think the matter is that the petitioner, he joined in the PhD program of IIT Guwahati, my lord, in the year 2016, January. He joined in the Department of Biosciences and Bioengineering, my lord. He finished all his coursework and only his comprehensive exam, the requirements of the PhD program, my lord, and he was to submit his research thesis finally. In 2017 May, my lord, what happened? He became sick, my lord. He developed a back pain. For that, he had to go on leave, my lord. He again joined back after, my lord, about 15 days. But he complained that he was being harassed by his supervisor. Every PhD student has a supervisor, my lord. One single supervisor, that is respondent number 4 here in my lord. I have included him as a party respondent. So his allegation was that he was being harassed, and he was all the precautions required to recover from the back pain. Also, he could not recover, my lord, because of the continuous harassment. He was made to stand for long hours, long durations. So again, he had to go on leave. Again, he joined back, my lord. Again, the harassment continued. Again, he had to go on leave in January 2018. My lord, so considering these reasons that there was clear incompatibility, he applied for a change in supervisor, my lord. That is permissible under the rules of the IIT Guwahati, my lord. The first application your lordship will find page number 42 onwards, my lord. 42 onwards are the conversations that he tried to seek a supervisor change. May I read, my lord? With due respect, I apologize for missing your calls as I left my mobile in the room. I will be very grateful to you if you allow me to meet you tomorrow and permit me to do the change in supervisor as per my request in the evening. Again, next page, my lord, the supervisor responded, you are absent from lab since last month and not performing any of your proposed experiments. Neither you have applied or taken any leave. Meet me and discuss urgently. He responds again, my lord, in page 44. With due respect, I want to state that I have already discussed with you regarding my change in supervisor and requested you for the same, but was unable to get a positive response. I will be very grateful to you if you grant my request so that I can start my work at the earliest. As per your request, I went to your office today, but due to your unavailability, could not meet you. Then he wrote to the head of the department, my lord, page 45. Again, for praying for supervisor change, my lord. I will skip that page, my lord. This is relevant, but the contents, your lordship will again, these are repeated in page number 46, all the details, my lord. This is another application for supervisor change. Page 46, my lord. Respected sir, it is with great pain and sorrow that I am writing this letter to you. My name is Sunayan Deka. I am doing my PhD in the Department of Biosciences and Bioengineering. I am writing to you about the cruel and unending mental harassment perpetrated by my supervisor, Dr. Lalit Mohan Pandey, assistant professor in the same department, on me. His behavior towards me is very disturbing and aggressive. I was suffering from serious health issues, spinal injury, and I am advised by doctor to follow some restrictions like not giving excessive stress to my back and undergo regular physiotherapy. But even in that case, I did not receive any support from him as he refused to allow me to go to physiotherapy, intentionally called me in his office and made me stand for long durations even after knowing my health condition. There was no respite even on Saturdays and other official holidays as he forces me to come to lab no matter whether I have work or no work. When I tried to discuss my problem, he just asked me to leave the lab and find new supervisor on repeated occasions. He also asked me to do his personal work like repairing his laptop, mobile, settling his medical insurance, etc. on numerous occasions. Due to these continuous harassments, I was unable to concentrate on my work and lost my mental peace. I have decided to have a supervisor change and discussed with him, citing my incompatibility issues with him. He who initially assured me to look after the matter completely refused my request after getting my application. He even did not allow my fellowship to be released, even after I marked my attendance in the department. He refused to sign my leave application. I was genuinely on medical leave and informed him on contingency form. I took the matter to respected HOD sir, and when my supervisor came to know this, he just yelled at me, threatening me that I am playing with my career and ticked the non-recommended option in my leave form. He gave example of my lab mates who reported against him, stating that I will suffer the same and nothing will happen to him. He said that even if a meeting is held in the department, my request will not be allowed and threatened that he may accuse me as an unsuitable student, for the lab after that. Sir, my supervisor himself is the DPPC secretary, and thus I am forced to approach you. I am undergoing continuous mental harassment and very much depressed, and under these circumstances, it makes very difficult for me to continue my research under him. I will be very grateful to you if you remedy the situation so that I can comfortably start my work. There is a procedure required that you have to apply to the DPPC and they have to approve the supervisor change. But the DPPC secretary was the supervisor himself, my lord. So I had initially gone to the higher authorities, my lord. But in that respect, my lord, the DPPC sat for a meeting. The procedure as per the DPPC, with the secretary as the respondent number 4 being the secretary, they sat, and the minutes are at page number 49. Page number 49, last para, my lord. Sunayan Deka, roll number 7 for my lord. The DPPC meeting was convened and
So
chaired,
after this letter,
my lord.
they have convened this meeting,
Yes, DPPC meeting, my lord. Departmental Postgraduate Committee. Departmental Postgraduate Committee, my lord.
Okay.
Program committee. So they are required to recommend and approve the change of supervisor. They disapproved, my lord. The DPPC meeting was convened and chaired by the head BSBE for this agenda item. The DPPC listened to the student and the recommendation of his DC, copy enclosed, was also discussed. It was decided that in absence of valid academic reason and also NOC from his supervisor, the supervisor change is not allowed. The student was recommended to continue his work in his laboratory and was asked to submit the satisfactory progress report from his supervisor for the release of his fellowship. This is my first round of challenge, my lord. He being the judge, he cannot sit and judge his own case, my lord. This is the settled principle of law, and principle of natural justice was violated here, my lord.
So in this meeting, he was there.
He is the DPPC secretary himself, my lord. He was there.
Is mandatory required to be there, my lord. Just to clarify the small point, because as per the rules, I'll produce the rules also. He being the secretary is supposed to be there, and both the sides are being heard in DPPC. not that only one-sided decisions are taken. So for this particular meeting, he was not acting as a secretary. He was acting as a guide. Just to clarify a small point here, my lord. I'll produce the rules also, my lord.
So that's all right, but do you have any document to show that on that day he had not participated in the meeting?
He was supposed to participate because DPPC, my lord, the rules which lays down IIT rules, it says that both DPPC will hear the researcher and the guide. It is not one-sided decisions which DPPC takes. These are academic institutions, my lord.
No. Complaint is basically against you. Then you have participated in the meeting.
That is what, my lord, I'm saying. The rule
No, maybe
mandates his
your rule may
participation.
permit it, but whether your rule is
My rule is not under challenge, my lord, here. My rule is not under challenge here. So, my rule is not under challenge here. Point one. Point two, my lord, there is a procedure. Because otherwise, what will happen, my lord? I'm sorry to interrupt my learned friend. What will happen otherwise, my lord? If there is there is a separate council to address on the point of the personal allegation which is there. I am only acting as an IIT's counsel, my lord, in this case. So what is there, my lord? In all cases in IIT, these are students are picked up. They make a request that which supervisor they want. It is not that IIT picks up an individual and puts it there. It is his request was there. Particular area, he wants to do a PhD, and accordingly, a supervisor who was there, that the professor who was there, he was allotted. Now, they may not be any, those parts will be addressed by the learned council there. But if there is anything, my lord will appreciate this, in an education institution of a repute, my lord, there may be some issues of the students with the supervisor, but that will not entitle a student to immediately change the supervisor or a guide. Because sometimes the guides may be hard on the part of the academic side. I'm not commenting on the personal side. But on the academic side, there may be some requirements. Maybe there is some experiment which the particular individual is failing. Or maybe his performance is not up to the mark. That will not entitle him to change the supervisor, which is actually probably would have happened. The reason may be here different, my lord. The reason is this person was probably working while he was pursuing PhD and taking assistance from IIT, he was probably doing a moonlighting job in somewhere else.
No, please don't submit that.
No,
That is
that will,
completely false and
that is for the court to decide. But what it appears is this, my lord, that there was multiple opportunities were given to him to address his grievance. I will demonstrate it. But just to clarify this point, my lord, DPPC will not, on all and every request of a supervisor change, they will not do it because our rules are very clear.
No, that's all right. Your role permits you, but are you supposed to take part in that meeting?
My lord, I am supposed to because
To decide your own
if the
case?
complaint is against me, my lord, if my lord will not hear me to decide the matter of what, man.
The authority will definitely hear you.
Yes, my lord. But I was not participating as a secretary, my lord. That is what, this is a misstatement here. I was not participating on that meeting as a secretary. I was participating as an guide who was supposed to be heard. That is what the rule is. The guide is supposed to be heard, the student is supposed to be heard, and thereafter, if the DPPC finds the reason is cogent, then a supervisor change is recommended because supervisor change there is only three situation when the supervisor can be changed. If my lord wants, I can directly take the rules. My lord will, if my lord wants to.
No, I will hear you. Pastor, let him complain.
Anyway, I have made pleadings to that effect. There was nothing in their response that, it was in the role of my lord, the guide, and not as a DPPC secretary. He was the DPPC secretary, my lord, at that point, undisputedly. Anyway, my lord, DPPC did not allow my supervisor change. Thereafter, they said that NOC, you get it from the supervisor. So again, I went back to the supervisor, my lord. Page number 54 onwards are my email conversations with the supervisor, my lord. Page number 54. With due respect, I want to state that it will be very difficult for me to write an apology letter for conveying my problems and sufferings. I will be very grateful to you if you release my money, last 3 months fellowship and contingency. And allow me to have a supervisor change so that these issues get settled as the continuous extension of these cases is hampering me academically, financially, and mentally. I will also be very thankful to you if you allow me to know the updates of my manuscript submitted in the Journal of Material Science and Engineering C after the reviewer's comments were received. Next page, the response of the supervisor. As per meeting with HOD, BSB, and subsequent meetings with lab members and along with your father, you agreed to apologize for your mistakes. You were suggested that both the options, either to join my lab or to take NOC. Further, you did not meet me since more than 3 weeks, despite several calls. You need to help yourself. In your absence, I am unable to help you. Further, for getting NOC, you need to take no dues from laboratory and submit an application for the same. Again, my lord, I wrote to him, with due respect and as requested earlier, I want to state that I want to have a supervisor change, as it will be very difficult for me to continue in my current lab under you. Thus, I will be very grateful to you if you give me NOC and allow me to have a supervisor change so that I can resume my work at the earliest. Again, he says, it appears you are not serious about your academic career and wasting your time. Today, again, you did not appear and writing email will not help you. As stated earlier, for getting NOC, you need to take no dues from laboratory and submit an application for the same. Page number 58. My lord, as per your directive, in order to get my NOC for supervisor change and no dues from laboratory, I am hereby attaching the datas of my research work. I want to apologize for not giving the datas in person as per your instruction, as I was not feeling well and had to consult the doctor for the same. I will be forwarding the remaining datas from my private mail as I have limited space in my institute mail. Again, Sunan wrote, my lord, on page 59, with due respect, I want to state that as per your directive in the DC meeting to find out my lost lab notebook, a Jaldhara notebook, in order to get NOC for supervisor change, I tried my best, but I apologize for my inability to find the same. Thus, I will be very grateful to you if you suggest me an option to get my NOC from you. He gave all the research data and everything, my lord, to get the supervisor change NOC, my lord. Thereafter, directly what happened, my lord, next step was the DPPC sat for another meeting, page number 80.
Yes.
Page number 80, last para, my lord. There was no notice issued before this, my lord. Hence, in view of their non-compliance to departmental recommendations and unsatisfactory report from their respective supervisors for more than 6 months, DPPC recommended for the termination of both the students from PhD program. One of the students is me, my lord. Directly, they, without any disciplinary proceeding initiated, the DPPC recommended my termination, my lord, and without issuing even a notice to me, my lord. The recommendation.
Is there any requirement?
Yes, yes, I will show that, my lord. I'll come to that, my lord. After that, after page 80, this went to the higher authority, that is the Senate of IIT Guwahati, my lord. Page number 82, item number 6, my lord. I will just read the entire portion for your lordship's convenience. To consider the recommendations of the DPPC, BSB for termination of 2 PhD students, Mr. Nilesh Nandan and Mr. Sunan Deka. Mr. Nilesh Nandan submitted a request for change of supervisor to the DPPC BSB in January 2018, and it was rejected by the DPPC BSB. But he was continuously making requests for change of supervisor. It may be noted that he has completed the comprehensive examination on 29/8/2017 and yet to deliver the state-of-the-art seminar. On 30/7/2018, the Chairman Senate has forwarded the email request of Mr. Nilesh Nandan to Professor K. Pakshirajan, Chairman DPPC BSBE, and requested to resolve the matter in the department level, which was copied to the Dean of Academic Affairs and to the Dean of Students Affairs. In response to this, on 6/8/2018, the DPPC BSB has made recommendations for termination of 2 PhD students, Mr. Nilesh Nandan and Mr. Sunan Deka, from the PhD program of the institute for not complying to the instructions of the departmental recommendations on the matter of change of PhD thesis supervisors, an unsatisfactory report from their respective supervisors for more than 6 months as placed at answer so-and-so. The Senate examined the recommendations of the DPPC BSB for termination of 2 PhD students, Mr. Nilesh Nandan and Mr. Sunan Deka, as stated above, and observed that the DPPC may review the matter. They said the DPPC may review the matter, but kindly come to the next resolution. The Senate resolved that the recommendations of the DPPC BSB for termination of 2 PhD students, Mr. Nilesh Nandan and Mr. Sunan Deka, as stated above, be approved. It is contradictory, my lord. They said it may be reviewed and then they say that it is approved, the termination, my lord. First, this is also very arbitrary, my lord. Secondly, then, my lord, after the Senate, before, and this also was without issuing any notice to me, my lord. After the Senate recommended my termination, page 83, a letter was issued to me, my lord. Although I have already been recommended to be terminated, they say, Dear Sunan, page 83, it has been brought to the notice of the BSBE office by your supervisor that you have been absent from your research laboratory for a long time. I am directed to advise you to meet your supervisor, Mr. Dr. Lalit M. Pandey, immediately and submit a written explanation in this regard to the department office, duly forwarded by Dr. Pandey on or before October 12, 2018. Failing to do so may invoke disciplinary action against you. After terminating me, they say that we may initiate disciplinary proceeding against you. They do initiate a disciplinary proceeding thereafter, my lord. Page number 84. The first email is the one below, my lord. Dear all, I propose to call a DDC meeting to discuss following agenda on October 29, 2018, 3 p.m. onwards. Agenda items. First is absence of Mr. Sunayan Deka from lab. Complaint made by Dr. Lalit M. Pandey. Second is not relevant, my lord. Thereafter, there was the above email, my lord. Dear all, there is a scheduled DDC meeting to discuss following agenda on October 29, 3 p.m. onwards. Agenda items number 1, absence of Mr. Sunayan Deka from lab, complaint made by Dr. Lalit M. Pandey. So after terminating, they initiated DDC meeting. And Lordship will kindly note this was a DDC meeting, this Departmental Disciplinary Committee, my lord. There are multiple disciplinary committees in IIT Guwahati. After this DDC meeting, my lord, I received a letter. I will also take your lordship to the minutes of the DDC meeting, my lord. That is at page number 216, my lord. It was brought in their affidavit in opposition. 216. Lordship, 216.
That is their affidavit.
That is in their affidavit, my lord.
Hmm.
They have brought this.
Is number?
216, my lord.
No, that
Running page number is 216, my lord. The,
Yes, my lord. It is
the
otherwise.
continuous page number is 69, otherwise. The internal page number 69. Running
69.
page number is 216, my lord.
Yes.
Yes, my lord. Lordship will kindly note that there was no charge sheet issued to me before this. Anyway, the agenda, the minutes say unauthorized absence of Mr. Sunayan Deka from lab, complained by Dr. Lalit M. Pandey. The committee discussed the matter of unauthorized absence of Mr. Sunayan Deka from Dr. Lalit M. Pandey's laboratory since February 2018. In addition, committee observed that Mr. Sunayan Deka is putting attendance through biometry, but afterwards does not do his assigned lab duties. In the meeting, all members are of opinion that Mr. Sunayan Deka is not cooperating with departmental activities and disobeying all suggestions or recommendations of DPPC to resolve the matter between him and supervisor. He was absent from the current meeting as well. Hence, considering all these points and observations, the DDC members are of opinion to recommend following action against him. Number 1, the DDC recommended that no fellowship will be released for him until he joins the laboratory and cooperates with the department to resolve the matter. Number 2, as student does not show up to lab or remain away from department after putting attendance through biometry, committee requests Dean Student Affairs to look into this matter and find out whereabouts of the student. If it is found that he remains away from institute campus after putting the attendance in department biometry, committee suggests to rusticate the student from institute hostel. This is the recommendation of the DDC, my lord. And it was in October 29 that they resolved that my.
Page number 69 is the minutes of the DPPC meeting held on 2/4
This is,
2018.
this DDC, my lord, Departmental Disciplinary Committee.
No, he has referred to this page 69.
Internal page, my,
Internal
running page 216, annexure 20,
annexure
20, my lord. R20. Chronologically, it is running page 216. This is in the affidavit filed by IIT Guwahati, my lord.
Hmm. Respondent number 4.
No, my lord, respondent number 1, 2, and 3. Even respondent number 4 will have the same, I think, my lord. Wait.
Oh. Definition वाला कौन है पढ़ा बताओ क्या हो गया याद
Traditional affidavit.
No, it is affidavit in opposition on behalf of respondent number 1, 2, and 3. Running page 216.
No, it starts in this file from 148.
Yes, yes, your lordship. It starts from 148.
Yes, here annexure
Annexure R20, my lord.
R20.
The last annexure, my lord. Last page of the affidavit.
Yes.
My lord has got it. Department of Biosciences and Bioengineering. Yes, my lord. Minutes of the Departmental Disciplinary Committee meeting. My lord, may kindly come to points 1 and 2, my lord, the of the first agenda. In the lower part of the page.
Yes.
DDC recommend that no fellowship will be released for him until he joins the laboratory and cooperates with department to resolve the matter. Second recommendation, a student does not show up to lab or remain away from department after putting attendance through biometry. Committee requests Dean Student Affairs to look into this matter and find out whereabout of the student. If it is found that he remains away from institute campus after putting the attendance in department biometry, committee suggests to rusticate the student from institute hostel. So, my lord, my termination was never even recommended by the DDC. They said that his fellowship be stopped from October 29, 2018. That would be coming to effect from November 2018. However, my supervisor had stopped my fellowship from February 2018. And secondly, my lord, they said that if there is a finding that I am not in the department or institute, then I may be rusticated from the hostel only, my lord. Even this is without jurisdiction. I'll come to that, my lord. In any case, although I was not recommended to be terminated, the next letter I received from the institute is the main impugned order, my lord. Page number 97 of my writ petition. Annexure 26, my termination, from the institute. Dear Mr. Deca, inviting reference to the mail sent to you from the office of the Department of BSBE, IIT Guwahati on 5th October 2018 regarding your absence from research laboratory for a long time. The undersigned is directed to inform you that you have been terminated from the PhD program of the institute as per PhD ordinance and regulations of the institute with immediate effect on account of following reasons. You are not adhering to the instructions of DPPC, BSB, and thesis supervisor. You are not attending doing research work of PhD for last several months. Without any disciplinary proceeding and recommendation, I was terminated, my lord, and without any charge sheet also. In any case, now I'll take your lordships to the relevant guidelines now.
So this MPO letter was issued on 7/1/2019.
My lord,
So till today, about 7 years elapsed.
lordship.
So what purpose will be served even if we set aside this?
Lordship, I will join and complete my PhD. It has been, I filed it in 2020, this writ petition, my lord.
Hmm.
Before the COVID. I
Hmm.
filed it then and thereafter have, it has been continuing.
What are you doing now?
My lord, I have done some jobs in the meantime, my lord. And now presently, I was a good student, my lord. I even worked at IIT Guwahati. My last job was at IIT Guwahati, but thereafter I resigned. Now I'm preparing for other examinations also, my lord. So because I have substantially, at least half of my PhD program is complete. Now I have to complete the rest remaining.
That is, my lord, probably incorrect statement. I will demonstrate after 2017, December, his SOAS, he has done nothing. And that is the reason the IIT has used that power.
Anyway, my lord, in lordship will kindly see the PhD ordinances and regulations. Clause 15.1 and 15.3.
Clause 1,
15.1 and
15.1. Yes.
15.1, it says that the regulations for conduct and discipline are common for all students of IIT Guwahati, and these are the same as that prescribed in the BTech rules and regulations. In addition, unauthorized absence for more than 1 month leads to disciplinary action in the form of reduction of assistantship or even termination of studentship. Next is cancellation of studentship. The PhD studentship is liable to be cancelled for any of the following reasons. One, giving false information at the time of application admission, not conforming to the regulations of the program, failure in coursework requirement, failure in comprehensive examination, consistent lack of progress in research, violation of discipline and conduct rules of the institute, not submitting a thesis within the stipulated period, not enrolling for a semester within stipulated dates. Regular, sponsored, and QIP, so and so, my lord. So for these reasons, they may institute a disciplinary proceeding and, if required, terminate my studentship, my lord. Now the conduct rules, my lord, that apply, the procedure to be followed, my lord. That your lordship will kindly find in my rejoinder affidavit, my lord, at page 335.
Yes.
Ordinance on code and conduct of students, my lord. This provides the procedure to be followed for disciplinary action. And lordship will see there are multiple committees at page number 340. The different kinds of committees, disciplinary committees that may be constituted, my lord. 340 clause 4.1.1 is the first one. 4.1.1 is hostel disciplinary committee. Second is 4.1.2 is institute hostel disciplinary committee. 4.1.3 is departmental disciplinary committee, which acted in my case, my lord. 4.1.4 is institute academic disciplinary committee. And last is 4.1.5 student disciplinary committee. Now, my lord, for when the DDC may act, it is in page number 341 itself, the last line, my lord. 4.3.2. Academic level violations, my lord. Disciplinary issues related to general conduct of students in the classrooms and laboratories shall be dealt with by the Departmental Disciplinary Committee, DDC, of the concerned department. These matters are minor in nature and restricted to a particular department. The DDC will deal with the matter and give appropriate punishment. If the issues are with respect to purely academic malpractices, then the respective charges shall be referred to Chairman Institute Academic Disciplinary Committee for approval. For any other disciplinary issues, the recommendations of the DDC shall be referred to Chairman Student Disciplinary Committee SDC for approval. If the issues are with respect to academic malpractices and have implications across the departments, the issues shall be dealt by IADC. The charges recommended by IADC will be endorsed by Chairman SDC and the same will be referred to Chairman Senate for approval and will be reported to the Senate. If the violations are of serious nature, IADC may refer the matters to SDC for further action. Upon approval, the charges related to purely academic malpractices will be intimated by Head of Student Affairs, Head of Section, Academics to the concerned people. All other charges will be intimated by Head of Section, Student Affairs, SA to the concerned people. So, my lord, there has to be a charge sheet which has to be by the competent authority and the same has to be issued to me, my lord. And thereafter, I have to respond to it. That principles of natural justice will requires that, my lord. In any case, what is the powers of the DDC, my lord? Kindly see page 345. P45, my lord. There is a table there. Committees and powers of punishment to be recommended or awarded, my lord. Kindly see the third is DDC. Reprimand, probation, suspension of departmental privileges, restitution, compensation for damage, fine up to rupees 5,000 on an individual. The DDC did not have the power to terminate me or rusticate me from the hostel or the institute also, my lord. Which the institute, they have not terminated me also. The next is the IADC and the SDC. Lordship will see in the last part, the last punishments that IADC can recommend is rustication and expulsion. And SDC also rustication and expulsion. It is only these two committees who can rusticate me from the institute, my lord.
So in your case, the decision was taken by DDC.
DDC and DDC said, if there is a finding that, I am not attending to the institute, I may be rusticated from the hostel, institute hostel. They went beyond that and directly terminated me from the institute, my lord. And IADC and SDC was not even there, my lord. So complete arbitrariness in the actions, my lord. And second, lordship, I just want to show that this is not the first complaint against respondent number 4. Several students have complained against him. Lordship will see, I have attached those letters by different students. Page number 124 onwards, my lord. Page number 124. It is an email by one Srijit Karmakar. Beloved scientific community, I, Srijit Karmakar, a research scholar in the Indian Institute of Technology, Guwahati, India, with great sorrow would like to bring to the notice of everyone that I had contemplated suicide a few days ago after losing all hope. Following is the suicide note which I had written before attempting to jump into the Brahmaputra river. However, I could not jump because it flashed in my mind at the end how the instances of suicides by researchers had been coffined and forgotten, giving an advantage to those who force these victims to walk on that path. When the voice of suffering is dead, the perpetrators can then walk free. I only have regret that I have to finally face this matter here, and after trying everything in my capacity to bring the solution for all possible ways I know, the suicide note to everyone who is still a human. I was born with talents very few people in nature are endowed with. I was also born with an unfortunate fate very few people are known to possess. I want everyone to know that the people who hold full responsibility for my death are: number 1, Dr. Lalit Mohan Pandey, Associate Professor, BSc, BSB, IIT Guwahati, for abusing me and inflicting the worst possible pain one can inflict upon a fellow human. He's the first person against whom these allegations are, my lord. This email continues with allegations against the respondent number 4, my lord. Fortunately, my lord, he did not take any untoward steps. Thereafter, my lord, page 132, his case, my lord, was considered by the IIT Guwahati. Page number 132. As a special, the second para, my lord. As a special case, you do not require to get consent from the present supervisor, and you may approach any faculty member of your department or any other department or centers of IIT Guwahati for the thesis supervision based on your interest. In case you wish to change department, consent from the present head of department is not required, but consent from the new supervisor department center is required. Similarly situated, we both are, my lord. And his case, he was allowed to change his supervisor without any NOC from the Dr. Lalit and Pandey. Next page, my lord, 133. Another student complains against him, my lord. Repeatedly this has been going on, my lord. Page 133, one Ajit Singh wrote this letter. My lord, may kindly come to para 3, my lord, therein, the last para of the page. I thought things will be fine after some time, but I was wrong and situation started becoming worse gradually. Everyday mental harassment and threatening, unethical involvement of his wife's name in the lab papers, chapters, and involve us into his family-related works are part of our daily life in IIT Guwahati. When we try to raise voices against these things, he, as usual, threatened all of us during the lab group meetings. Last year, I raised my voice against all these unethical things in lab, but later on, he made me helpless and also had forced me to write an apology letter, which was kept by him. Because of my family responsibilities, I continued facing these harassments as part of my daily life, even after writing apology letter. After taking the letter, he kept threatening me by saying that if you will complain now to the present President of India also, nobody will believe on your facts, and I will make sure that you will not get your PhD degree. How things have become intolerable to me, which are throwing me continuously towards the black side of thoughts. Finally, I have collected my courage to write all these facts to the MHRD as well as our beloved Prime Minister, Sri Narendra Modi ji, at the cost of my career as well as my life in IIT Guwahati after reading one quote which says so and so, my lord. Another complaint against him was there. My lord will see page 140. There's another complaint of student harassment by one Simon Dara. I'll not read it all, my lord. And again, page 146, also another complaint by a separate student. So, my lord, these. Okay, my lord. So, lordship, in my humble submission from the very initiation, he sat as a judge in his own case, my lord. There was the recommendation for termination by the DPPC and the Senate was without issuing any notice to me, my lord, without issuing any charge sheet to me, and without issuing any
This impugn letter is at page number
my lord, 97,
97.
my lord.
And next are 26.
Lordship.
And what is the decision taken by the DDC?
My lord, page number 216.
Is it page number annexer 23? No.
No, my lord, it is not in my petition, my lord. It is there in the
There.
affidavit.
Page number
216, my lord.
216. Yes, that is affidavit in opposition.
Lordship.
Yes.
Okay.
Paragraph, no, this, annexer number
R20, my lord.
R20.
Lordship, there was no charge sheet at all, of course. I may rely on couple of judgments, my lord.
Petition
24, 1 SCC, 632,
2024.
Yeah.
1 SCC
63,
49.
Aureliano Fernandez.
But this, page number 69 or annexer R20.
Lordship.
So you have been, suggested to rusticate
Yes,
the hostel.
yes. Only if there is a finding that I remain away from the institute campus. So she was only. There
So
has to be
this
a-
power is not vested with this DDC.
No, my lord.
And any other important page?
My lord, even the first recommendation that no fellowship will be released, that also is not with, that power is also not there with the DDC.
What are the judgments?
My lord, one Aureliano Fernandez, first judgment, my lord. This is on Article 14, page 655.
Page
655. Para 35.
yes.
Clause G, Article 14, bedrock of principles of natural justice. The principles of natural justice that are reflected in Article 311 are not an empty incantation. They form the very bedrock of Article 14, and any violation of these principles amounts to a violation of Article 14 of the Constitution. Denial of the principles of natural justice to a public servant can invalidate a decision taken on the ground that it is hid by the vice of arbitrariness and would result in depriving a public servant of equal protection of law. Para 36, Article 14, often described as the constitutional guardian of the principles of natural justice, expressly forbids the state, as defined in Article 12, from denying to any person equality before the law or equal protection of the laws. Article 14 provides an express guarantee of equality before the law to all persons and extends a protection to them against discrimination by any law. Article 13(3)(a) defines law to include any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Thus, principles of natural justice guaranteed under Article 14 prohibit a decision-making adjudicatory authority from taking any arbitrary action, be it substantive or procedural in nature. These principles of natural justice, that are a natural law, have evolved over a period of time and have been continuously refined through the process of expansive judicial interpretation. The twin anchors, nemo judex in causa sua and audi alteram partem. The twin anchors.
Okay, all right, not
My lord.
necessary to read out the entire paragraph.
Lordship.
All right. Next one.
Well, there is one judgment, 2018-17 SCC 677, Pramod Kumar, State of Tamil Nadu versus Pramod Kumar.
677.
Yes. Which is the relevant paragraph?
Yes, my lord, just one para, one line, my lord. I will- Para 23, my lord.
Yes.
Para 23, it is also settled law that if the rule requires something to be done in a particular manner, it should be done either in the same manner or not at all. Just that much, my lord.
Next one.
My lord, I have given one judgment 2025 SCC online SC 331, Amit Kumar and others. 2020. 2020, I have given to your lordship, I think.
No, you have not given, no?
My lord, I have given that judgment. Amit Kumar and others. 2025 SCC online, SC 60.
Yes, yes.
My lord, this I will not read out this judgment, but Honorable Supreme Court has recently constituted a task force, my lord, to address the mental health concerns of students and prevent the commission of suicides in higher educational institutions, my lord. So the Honorable Supreme Court is also cognizant of the vulnerability of the students, my lord, in these higher institutions. My lord. And Vikrant Singh, my lord, there is a judgment of this Honorable Court. This is a recent judgment, my lord, where also the principles of natural justice was violated, and that's why a PhD student was reinstated, my lord. Okay. Okay. Another relevant page, my lord, would be that the reinstatement of Srijit Karmakar, which I have showed, my lord, because I am, that is page number 132, my lord, of my petition. Here, a similarly situated student was allowed to change his supervisor, my lord, without getting an NOC from the supervisor.
130?
132, my lord. Here, my lord, if that student was allowed, I am not allowed, my lord. So violation of Article 14 is what I am submitting, my lord. Violation of equality. And the same supervisor is also the person against whom the allegations were.
Yes.
Lordship, that is my submission.
Okay.
My lord, would like to hear the counsel for the EA first, or shall I start? Because I will be only limiting to myself to the, because there are certain personal allegations which have been made against the respondent number 4. Mr. Das has just gone to some other court. He has told me that he has gone to some other court.
You are not representing.
No, I'm not representing.
You are.
I'm
you are
only
for IIT.
I'm only for IIT, my lord. So Das will be required to be heard because there is certain, this entire case which has been projected is a project. If I understand correctly, is this that there's a bias of Mr. Das's client and accordingly everything is followed. That is what I understand from
No,
submissions.
the question is whether he can participate in the meeting.
But I'll satisfy that. No problem. I'll satisfy. If my lord wants, then I'll start.
If, since he is not present now, you can start.
My lord, deeply obliged. For that case, my lord will take up my affidavit because my lord, I have to read certain pleadings. My lord will allow me that indulgence. Indulge me for some time, my lord. Let me. For facts in this case will be important. To before adjudicating what has happened. This is a case where the student has repeatedly was given an opportunity by IIT to complete his PhD program, he did not took any steps to do it. Now let me, my lord, start on page number 149, my lord. Let me read certain paragraphs, that will
Yes.
give some perspective. Para 5. Page number 149, internal page number 2, my lord, para 5. My lord, may I?
Okay.
The petitioner has falsely stated in para number 3 of the petition that it is only after the admission he was informed of his supervisor of Dr. L.M. Pandey. So one of the contentions which was raised in the writ petition that he never knew, and Mr. Pandey was as if IIT has imposed Mr. Pandey upon him. Now let me give a prelude to this, my lord. So, my lord, as far as my instructions goes, this petitioner and one of his probably colleague and somebody, it's called Varun Saxena. This name comes, my lord. He has made a specific allegation also against that individual. That individual and petitioner in the year 2015 passed out from Pondicherry University. This is my instructions, my lord. Now, Mr. Saxena was working in the lab of Mr. Pandey. And after that, petitioner joins sometime later, or probably at that. So it is not a case that he had no idea because his friend or acquaintance was working with the lab of Mr. Pandey. So that entire projection that petitioner had no control, no say on his supervisor selection, that is incorrect. Petitioner was aware, maybe not fully, but some idea he had what is the supervisor. Now let me show you what is the procedure which IIT follows for supervisor selection. By stating, the same paragraph, my lord. By stating so, he is trying to give an impression that the institute authority had imposed Dr. L.M. Pandey as his supervisor without taking his prior consent. The deponent begged to state that the petitioner is trying to mislead the Honorable Court with an ulterior motive. The deponent states that the purpose of information, the fresh candidate about the research area and research subjects available in the institute, and also about the names of the subject-wise respective supervisors. Institute authority used to put up 2 notices meant for fresh candidate. The notice in the notice board, in one notice, total 18 number of research areas, that is research subjects, would be available during the PhD, available for pursuing the PhD program by the students were displayed, and the candidates were required to choose their research subjects in order of preference. The second notice, the names of the respective faculty supervisors as against each research subjects were mentioned to enable the candidates to know the names of respective supervisor in advance against each research subject before they could select their subject. As a result, before choosing research subject, each candidate knew in advance the respective names of the faculty who would be supervisor in his subject. The petitioner accordingly had chosen the research subject biointerfaces and biomaterials biochemical engineering as his first preference subject at serial number 13 of the aforesaid notice. It is shown that Dr. L.M. Pandey would be supervisor in the subject, in the research subject biointerference and biomaterials biochemical engineering, which was chosen by the petitioner as his first preference subject. Therefore, it is clearly evident that while choosing his first preference research subject, petitioner knew that Dr. Pandey would be his supervisor in pursuing the PhD program in the subject. Thereafter, having seen the list of available research subjects, the names of the respective subject-wise supervisor, petitioner had given written consent to do his PhD in the research subject biointerference and biomaterials biochemical interference as his preference 1, knowing well in advance if the first preference subject is allotted to him, Dr. Pandey will be his supervisor. In this regard, respectfully, so what we have tried to the projection which was being made by the petitioner that he had no role in selecting the supervisor, and IIT has willfully imposed a supervisor which is so draconian upon him, is absolutely baseless, foundationally erroneous, my lord. So the argument that the bias existed prior, this is false, my lord. So contrary to a young HSLC pass, so we have juxtaposed, my lord, an MTech student within student which is BTech student. Now, BTech student may not know. Now, in this case, as I told my lord, as per my instruction, one of the his acquaintances was pursuing PhD program in this particular lab of Mr. Pandey. If I understand the instruction correctly, so he would be having an idea. So this argument, ki, look, this guy is an harasser and all this and all that, that my lord I'll demonstrate. It's my lord is basically an afterthought. It's a got up argument which has been made here. My lord, a few lines thereafter. Therefore, my lord has got the word thereafter. Therefore, he cannot claim that being new to the institute, he joined PhD program without knowing the procedures laid down in the PhD ordinance of the IIT Guwahati. In fact, to choose research subject and respective subject-wise supervisor, he was not even required to read PhD ordinance because all details were about the research subjects and the names of subject-wise supervisors were displayed in the above mentioned notice. So we have, therefore, my lord, we have demonstrated why this EA, what is now, my lord, and we have in the annexure R1 and R2 are, my lord, first annexures, which I like to take this to put through in page number 180, running page number 180. Now, my lord will see his preference was this is his signed form, my lord. His preference number one was biointerference and biomaterials, biochemical engineering. Preference number 1. Preference number 2 was something. Accordingly, he has given a preference. And in the research area, my lord will see in point number 13. My lord has got that. So Lalit Mohan Pandey's name appears. There is a vacancy in his lab of one student, and accordingly, he was allotted that position in this case. Now, my lord, before proceeding further, let me now also take this honorable code to the PhD ordinance side by side, because I think, my lord, it will be little convenient. My lord, has that PhD ordinance? If my lord,
Yes.
Acha, my lord, before starting, let me clarify this position so that once so his studentship has been cancelled, my lord. So there is an, even though the semantics of disciplinary proceeding and disciplinary things are there, but because there was his case falls into 16 clause, I will take you through, my lord. But I'm just clarifying this position before that his studentship was cancelled. My lord has to keep this thing in. I will request my lord to keep this thing in mind while proceeding. Now, my lord will see the ordinance point 0.1. Institute Guwahati awards degree of PhD, engineering such and such. Point number 4, straight, my lord will see. A candidate becomes eligible for the award of PhD degree after fulfilling all academic requirements prescribed by the Senate of the Institute. So, my lord, until and unless you do not possess all the requirements, you will not be granted PhD, and in a vice versa, your studentship can be cancelled. Now, my lord, will turn overleaf. And my lord will see that there are few committees, my lord. I will briefly mention it here and then probably we'll take it forward, my lord. My lord will see point 2.1. So, because my lord has to keep it this in juxtapose, my lord. While in the disciplinary, purely disciplinary cases are dealt with, my lord, the conduct rules, which my learned friend was showing, the DDC, SDC, IADC, and others. If there is an academic non-performance, it is been dealt by the academic section and under this ordinance, my lord. So, point 2.1, my lord. So, Institute Postgraduate Program Committee, and there is a DPPC, there is Departmental Department of Postgraduate Program Committee. So these are the two committees which decides with regard to the, or everything with regard to the academic side, my lord, not the disciplinary side. They are looking into it. Academic side, if somebody is not performing, if somebody is regularly absent for a long time, what is to be done? All things academic side is being looked into by these two committees. Now, point 4.1, my lord, for a moment. Institute assistantships, that is assistant means, my lord, they will be paid money and all, that what the point was made, that there was his assistantship was stopped by the EA, by the respond number 4. Now, when it will be paid, my lord, this is the 4 criteria are there. Point 4.1. Institute assistantship will be available to an eligible student as per prevailing norms. Point 4.3, my lord, will jump. Students receiving assistantship from the institute or fellowship from the other funding agencies are required to perform academic duties as per prevailing norms. 4. Continuation of assistantship or fellowship is a subject of the satisfactory performance of the assigned duties and satisfactory progresses of the students in the PhD program. I'll pause here for a moment, my lord, before going further. Now, my lord, one argument was, because I was on the same point, so I took this course. One argument was made that his assistantship was stopped by the respond number 4. That is not the case, my lord. The case is this: if you fail to qualify 4.3 and 4.4, only on that case assistantship will be given to you, otherwise not. My lord, I hope I'm able to draw the point. Now, my lord, the first point which has been argued by my friend was here, is that he was under medical leave and therefore he has, yeah, I'm sorry. So the first point of leave was argued. Now, my lord, will look into the record for a moment. Para number 8 of my affidavit, my lord, will come to the affidavit. I'll go back and forth of my affidavit because, my lord, it will be convenient, my lord. Now, the case projected is this, my lord, that even though he is there, that even though there was an injury on his part and there was some spinal injury, but the respondent number 4 was so inconsiderate, he had not given him the leave, and accordingly he had to suffer and all. Now, this is para number 8, my lord, will see. The petitioner, the deponent state that the petitioner had applied for medical leave of 17 days from 8/5/2017 to 24/5/2017, which was recommended by his supervisor and approved by the department. Now, this was the first leave, my lord.
You were reading paragraph number?
8, my lord. So he says that he was made to work on Saturday. This point I'll also come, but first medical leave, that he was not granted medical leave and his leaves were blocked and something like that was argued. Page number 182, my lord, will come. Now, as per IIT's leave rules, my lord, I will take you through, my lord, the leave rules also. But let me put the facts first, my lord. So, as per IIT's rules, my lord, there is only a number of days which you can take leave from the institute. And for taking medical leave, you have to show documents. So, when he has applied to his supervisor for medical leave, the supervisor has actually allowed his leave for 17 days. So, page number 182, my lord. My lord will see the point number 1, nature and period of the leave for academic leave, maternity leave, paternity leave, etc. with supporting papers. So, from 8/5/2017 to 24/5/2017, 17 days leave was granted, recommended. 24/5/2017. That was, my lord. And my lord will see this was approved by at the last signatures, approved by the HOD and department, everybody. Now, my lord will come to, my lord has seen that. So his leave was approved. It is not that he was not given leave and he was made to work, even though there was a spinal injury on the part. That is not true, my lord. Because my lord, you also have to see, this is a case where a PhD student was pursuing his PhD studies, his PhD course. IIT has maximum year within which you can to finish your PhD course. Sometimes people are allowed to take semester drops. In this case, he has not done that. If he was actually injured, if he was unwell, he could have asked for semester drop. He did not do so. He continued this pretext that I will come, but I will take a leave or something or other, and he drew it such a manner that ultimately IIT had to cancel his studentship. He has not taken semester drop. Semester drop he could have taken. If he was unwell, if he was not, his back was not recovering, he could have taken medical semester drop. I will show that also, my lord. Para number 10, my lord, for a moment. Now, deponent states that in the month of, now the story is of this medical history, my lord. The deponent states that in the month of June 2017, petitioner was absent for the lab 15 days. So, May, my lord, have seen. May he has, I have shown 15 days, 17 days leave in para number 8. 17 days was granted to him. Same page, my lord, 153. Page number 153, my lord. Para number 8, first he was granted 17 days leave. Now again in the month of June, he was granted another 15 days leave. An argument was at least in the pleading, there is a point that even though he was unwell, he was made to work on Saturday, Sunday and all that in the month of June. That is a specific rebuttal is there. Man will see. In the month of June 2017, petitioner was present in lab for only 15 days. 15 days was again, he was not attending and did not attend Saturdays. On 10th afternoon, 17th, 24th June, he required medical help. So he was given due consideration, preference. Petitioner was attending physiotherapy sessions as advised by the IIT in his doctor in the evening in IIT Guwahati Hospital. IIT Guwahati has a proper hospital inside, my lord. He was attending physiotherapy. It is for the students to conveniently manage both work and physiotherapy session. A student is also entitled for an ordinary medical leave subject to the advice of the doctor at the institute. In this regard, deponents state the institute authorities are always sympathetic towards required medical leave. So again, as I was telling, my lord, it is not the case that institute was absolutely unsympathetic towards him. He was given due time to recover, physiotherapy session and everything. Still the argument was made. Now, my lord will see my annexion number 4. That is in the page number 183. So 17 days in the May, 15 days again in the June, my lord. We are still in 2017, my lord. Page number 183. So for first, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th is a Sunday. 10th, he was present. Then on 12th, he was absent both time at the evening and morning. 13th, he was absent in the morning. That it continues that way. And he was continuously absent and present without any proper justifications. And the EA was also, respondent number 4 had considered these things. And that is the reason IIT is also immediately did not took any harsh action against him, my lord. It is only because there was a repeated, that point has not been addressed by my learned friend, is that he was absent in the month from February 2018 till December 2018. Before that, 171 days he was absent also. So June, my lord, have seen his attendance record is there. The original copy, my lord, is the direct copy with the page number 184. Now, my lord, let me read para number 11, also important, my lord. As per the state such and such, the deponent states that, second line, the petitioner was always allowed to avail medical help and attend physiotherapy sessions. Petitioner took 60 medical leaves during 24/6/2017 to 27/8/2017 as a special case. As per the rules, PhD student is entitled only 15 days of ordinary leave in a semester and 15 days of medical leave in a year. The petitioner had already exhausted his medical leave in the May itself. As a special case, on a compassionate ground, his medical leave was recommended by his supervisor and approved by the institute sanctioning the leave. The extract copy of recording regarding petitioner above medical application and that my lord will now see annexation number 5. So yes, my lord. Before I go to annexation number 5, my lord, two small points just to recapitulate. IIT as a matter, my lord, has 15 days of ordinary leave you can take, 15 days medical leave you can take. As because he has taken 17 days in the May itself, his medical leave was over. Still, as a special case, in the June, he has shown, my lord, he was absent for 15 days. He was present for 15 days, so June is a 30 days month, probably 15 days again. Again here, from 24/6/2017 till 27/8/2017, he was absent for 60 days. That 60 days was also condoned by the IIT as a special case, my lord. And he's now, my lord, will see page number 185. Again, my lord will see Dr. Lalit M. Pandey has recommended the leave. In the signatures, recommended his leave. They have made some calculations, and in the note, my lord will see it is written 45 days of scholarship, 15 days without scholarship is approved. So my lord has seen the assistantship principle is there. As in Mr. IIT also is also bound by the rules, my lord. IIT cannot go beyond its own rules to give favors to students out of the way. We can only give assistantship as per our PA. In this case also, my lord, he was considered, due leave was given. Whatever has transpired, this allegation of back and forth, that personal work and all that, I'm not touching that, my lord. But from the record itself, it is appearing that Mr. Pandey has actually been very considerate to him. Because without his recommendation, leave would not be possible, my lord. Now, my lord has seen, my lord will take it.
After 5 minutes.
My lord, my lord, indulge me for some time, my lord. I will like to take you through the.
But be brief. Yes.
My lord. Why I took it, my lord, because there is a jump from leave, from medical leave to the supervisor team. There is a jump of probably close to 6 months odd. If that jump is not explained, my lord will not, I will not be able to see why the IIT has taken that step. So this was the reason my lord. So my lord has seen till May, June, 60 days delay, and his leave was accordingly approved by the supervisor. There was another allegation was made, my lord, but that was not, I think, pressed by the that then on the case, those allegations I will not touch, my lord. That there was an allegation that supervisor. So what happens, my lord? And my lord will either take the IIT ordinance for a moment. I will take you through two things so that my lord appreciates. So there is something, my lord, called in the 10.1. I'll just read the broad headings, my lord. Will probably will pick it.
10.1.
Yeah. So broad heading is closed. It's something called doctoral committee. And my lord has got it. In above the coursework, there is something called doctoral committee, point number 9. My lord has seen that. Now there is something called coursework. Now, what happens generally when a student is admitted, his supervisor is selected, then they do the first coursework. There is something foundational study is there. foundation of exams are there. After that, there is something called state of art seminar. That my lord will find in para number 12. So I am saying the flow, my lord, of PhD, how it goes. So his his state of art seminar was in 2017 December. Now let me read the state of art seminar for a moment, my lord, before going further. Within 6 months of successfully completion of comprehensive examination, student presents a state of art seminar. The presentation is open to all. In this, he or she presents his literature survey. Students 12.2, my lord. Student submits a write-up to the DC member. Now, DC here is, my lord, it's a doctoral committee. The doctoral committee is not only the supervisor himself. That is point number 9, my lord. Now, doctoral committee will decide whether his topic for his synopsis and all are proper or not. To monitor the progress of a research, my lord has got the doctoral committee. 9.1.
Got it.
Monitor the progress of research of a student. There will be a doctoral committee within following composition. A faculty member other than the supervisor will be the chairman. Supervisor has no role. First. Second, the supervisor will be the member. 2 other faculty members, which should be preferably be from the another department. DC then is 9.2, my lord. DC is constituted by the DPCC, DPPC. In consultation with the supervisor, within 1 month from the date of appointment of the supervisor, the list of the chairman, IPPC, until DC is constituted, DPPC accesses and do the duty of DC. So once he has started his PhD program, this DC was appointed. He first finished his comprehensive examination. Then his state of art seminar was supposed to happen. So he was supposed to submit a write-up for his seminar. Then, my lord, a report of the successful completion of SOAS submitted to the DC, to the secretary of DPPC, who communicates to the chairman of IPPC. Within a month, student delivers another SOAS if the first SOAS is not satisfactory. So state of art seminar is, my lord, a threshold. What I respectfully submitted here, my lord, in 2017 December, after his completion of state of art seminar, this entire story develops. I want to change. I want to do this, do that. Everything starts from there. And there is no progress from his part. Neither there is any effort from him from 2018 beginning till he has been rusticated in 2019 to improve upon his PhD program. Even though there was another supervisor, my lord. That is the story also. I will now demonstrate. Now, my lord will see, I will come to this, but this progress review is there. After the DC, after the SOAS, a student in 13.1, my lord, after state of art seminar, a student submits at least one progress report for yearly evaluation of the DC. A DC schedules meeting where the student presents his report. 13.2, DC reviews the progress and submits his report to the chairman, IPCC, to the secretary of DPPC after every such review. It is a fact, my lord, that after his state of art seminar, there was no progress report submitted by him to his DC. Now, my lord has seen DC. What is the role of DC? Now, what was the allegation? I'll just briefly touch this point. There was an allegation leveled in the petition. In the pleadings that, look, my DC was supposed to be my presentation was supposed to be held on the month of December. You intimated as a supervisor 2 days before you intimated me that I had to submit my report. And a case was trying to be projected that there was a bias and intentionally the respondent number 4 has done it. In the pleadings, it is there. IIT has responded to that. Now, my lord, what has happened in the IIT system, my lord? There is an academic calendar prepared at the beginning of the year. At the beginning of the year, everybody knows when I am supposed to submit my SOAS, that is my seminar, when it is supposed to be conducted. These dates were already, he was already aware of these dates. But he did not do anything. Generally, what happens, this DC, this is a group of professors, well, they see and they evaluate your progress, your seminar, your synopsis are evaluated in a PhD. These dates are fixed by the supervisor. Basically, the student comes to the supervisor and they think, okay, this date is the convenient date for me, I'll finish everything up. Please organize my DC. In the calendar, there is a cutoff date is given. After this date, there will not be any DC. My lord is able to appreciate that. This allegation was leveled, but when IIT has responded to that, that it was your duty, you knew the dates beforehand, that when this DC was supposed to be conducted, when your SOS seminar was supposed to be conducted. Probably because, my lord, as he was absent for a long time in the month of June and August, probably in the month of May also, he probably would not have been able to complete it. So, to flip it, my lord, what he has done, this gentleman writes to PMO, my lord, at sometime on 10/12/2017, my lord. That is just 3 days prior to his calling of his SOS. That fact, my lord, IIT specifically mentioned in para number 15 of my affidavit, my lord. So it appears, my lord, as because he was probably not able to match up the timelines to build up a pressure, he writes to a PMO. All of a sudden, even though his leave, my lord, have seen annexure 4, 3 and 4, his leave was allowed by respondent number 4. Extra leave was also given. This allegation was labeled one. One more allegation was, my lord, I'm just touching this because then will, my lord, will like to go something. Okay. So, my lord is seen till SOS, till September, my lord, everything is, sorry, till December, my lord, he completes his SOS. That is his seminar. Now, my lord, if my lord will turn to page number for a moment, my lord, 187. That is his complete attendance in the year of 2017 is desktop of my lord. Now, March 87, 187, the type code. My lord will just see the date. March, 2 days absent. My lord has got. April, 5 days absent, 2017. May, 20 days absent. June, 12 days absent. July, 31 days absent. Page number 188. August, 27 days absent. Then September again 3 days. Then from October, because his BC was in A, December. So my lord will see interesting till DC the days are 8 days, 7 days. And after that seminar, my lord, that SOS seminar, again in the month of January 2018, 28 days absent. February, 28 days absent. Now, my lord, at the same point, my lord, because I'm at the same point, my lord will take up my additional evidence. My lord, I have filed an additional affidavit on 29/2/2024. My lord, you just keep this page open and take up page number 362. This is my additional affidavit. My lord,
Yes.
yes, my lord. My lord has got page number 362. My lord will now open to page number 363. 363, my lord. So this is the entire his attendance record from March onwards, my lord. So March, my lord, you will see he's at 9:30 a.m. My lord has seen the original record is there. Xerox copy of the original record. March 2018 on the top of the page, page number 363. So Sunayan Deka, 9:30 a.m. There are two shifts as I have read, my lord. 2 times you can come to the lab. So 9:30 a.m. who has come and 6:30 a.m. who has come. So at 9:30 a.m. entire month of March he was absent. Column number 2, man. My lord has seen.
Mm.
Now, my lord, Suno and Deka again at the 6:30 p.m. in the evening shift also on the month of March, entire day is absent. Till February, my lord has seen, January, my lord has seen, now seen March 1. No reason whatsoever, my lord. No reason in his pleading, no reason, nothing, nowhere. My lord, now turn to page number 364, April. Point number 2, Sunan Deka. Full month of April absent in the morning, in the evening, full month of April absent, 6:30 p.m. My lord has seen. My lord will turn to May. Next page. Sunan Deka is at the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 13th number. Sunan Deka's name is featuring in the 9:30 a.m. Entire year he is absent. Probably the last part is cut. Or he will be absent in the month of May also. It is not his case also that he was present in month of May. Now June, my lord. Entire June, PhD, my lord is seen. Same after Ravi, Sunan Deka, entire month is absent. No reasons, nothing, absolutely silent. All allegations are on the IIT that IIT has conducted the proceedings mischievously and whatnot. Then, my lord, July, 367, my lord. Sunan Deka, entire month of July absent. My lord has seen July. Now, my lord, turn to August. The same story follows in August. Sunan Deka, entire month absent. So, September again. It goes on. September, entire September absent. In the month of October is page number 370. 12 number item, entire October absent. Next page also, my lord. October is continuing, page number 371, entire October is absent. Now, my lord, point number 13, PhD Sunan Deka. Entire October, entire November absent. Unfortunately, in the month of December, entire December is absent. Now, my lord, for a moment, I will pause and my lord I will again take my lord to the cancellation wala part, that is 16 of my ordinance, my lord, for a moment. My lord, why it is necessary, my lord? Because my lord has to see this is an academic institution, my lord. This is not in court of law or some EA where things are different. So, my lord, in 16, my lord,
In court of law, things are different.
my lord, strict law of evidence is followed, my lord. What I'm trying to say, my lord, the strict law of evidence is not followed because this is an education institution, my lord, and that is what is written in my rules also, my lord.
No, it does not mean that you can do
Well,
at
I have
your
not
whim
done it,
and
my lord.
caprice.
I'll demonstrate, my lord. I have not done that also.
Mm.
I'll demonstrate that also. Now, in 16, my lord,
Mm.
my lord, is see point number 9. So, as I was telling, my lord, is a cancellation of studentship, my lord. So, regular or sponsored or full-time or QIP category student remaining absent for
Referring to
16 one, my lord. 16, point number 16 in the my ordinance, my lord.
yes.
So, regular, sponsored or QIP category students, my lord. QIP is, my lord, something else that I am not going. Regular, my lord, he is a regular student. Absent for more than 6 weeks in a semester without sanction leave results to the cancellation of his studentship. Apart from, so here 3 points, my lord. We'll see point number 16.1, Roman 9.
Mm.
16.1.5, consistent lack of progress. That will also demonstrate this point. And failure in the coursework requirement. So if any of these is triggered, my lord, it is automatically cancellation. And that is not subject to 15.1 or 50.2. IIT as a matter of practice, my lord, has done it in other cases also. 15.2 has a different connotation, 16 has a different connotation. So here, this gentleman was prolonged absent. My lord has seen in the entire 2018. There was no progress after 2017, his SOAS. Thus, IIT has exercised this power under 16.19 and also 16 point, the powers under 16.1, my lord, and that has resulted to cancellation of studentship. Now let me come back to again my paragraph which I was taking through, my lord. Now, my lord, para number 16, my lord, will now see, and 15, my lord, for a moment of my appendix.
Yes.
Yes, sir. So, 15, page number 150. That has regard to the statement as such, that the petitioner had become insincere towards his research work and was not devoting enough time to work during his several months of 2017 and 18. As per the attendance record in the laboratory of the supervisor, he was absent for 171 days from the laboratory during the March 2017 to February 2018. My lord has got that line. While other students in the group were, my lord, got that? Other students in the group were continuously working. It is now clear that with malicious intention to cover up his fault, he has resorted to false and wild allegation. They stated that exam, that SOS of petitioner was scheduled on 13/12/2017. He filed a complaint on the petition on the PMO on 10/12/2017, as I told you, my 3 days before. Now, my lord, will turn over leaf and we'll see para number 16. So, here, my lord, there was another issue which was being brought by petitioner, that his medical leave was not sanctioned. And what is the procedure, my lord? IIT has described that. Petitioner first submitted his medical leave application for in para number 18, my lord, 16, my lord. I'm sorry. Now, this is in 18 January, my lord. First submitted medical leave application on 1/3/2018 for a period of. So in 2018, that the first leave application which he made was the backdated leave application. For a period of 8/1/2018 to 18/1/2018 without attaching any medical certificate of the doctor of the hospital of IIT, Guwahati, which requires as per rule. Our rules mandate that in case if you want a medical leave, you have to attach a certificate. That point has been explained here that even though it is not been done, thus his leave was not, but ultimately his application was. In fact, in an earlier occasion, that petition of sanction leave, his leaves were exhausted. So this was that. Para number 17, my lord. So I will just read 2-3 lines from here, then I'll come to his submissions on this point. Stated that had been significantly irregular for a long period of time. As per the attendance record of the laboratory, he is absent of 171 days. That is only to the February. After February, my lord has seen. Petitioner has resorted false and baseless allegation. Then in the second paragraph, my lord, that unnumbered second paragraph, it is stated that after presenting his SOS, the petitioner was again absent from the lab of 5/1/2018 till 7/1/2019 up to the date of termination. So, apart from his leave, my lord, there was no progress with regard to his PhD program. Thus, if there is no progress with regard to PhD program, after SOS, he is liable to be terminated, cancelled. Studentship can be cancelled. And my lord has seen there is a mandatory requirement that every year you have to submit your progress report to the DC. Further, it is now this is what IIT has submitted, my lord. Probably what was the basis? Probably it has come to be known that the petitioner was already involved in giving coaching lessons in a private institute named Short Dose Education. Photograph has been seen in the website of Short Dose Education as a team member, along with others. It is presumed that the petitioner research work at IIT laboratory came in his way of taking up this. So what IIT, I'm not reading it out, I've shortly to submit my lord that it has come to the IIT's attention that the petitioner at the same time when, or at the same time little later, his name was featuring into this educational coaching institute. So that is an conjecture, that is an assumption of IIT my lord, that he was probably doing this. Now my lord will see that with regard to his change of till my lord has seen his attendance. Now my lord will see with regard to the point of his application for the change. The second point which he has raised first, my lord will see page number. Yes. Page number, my lord. Page number 204, my lord. 204 is with regard to his is with regard to his fellowship, my lord. So for fellowship, my lord has been 4.1 also. 4.3 also, what is the requirement is 4.3. Now, it was stated to him that I am directed, this is the mail which has been communicated to him. I am directed to inform you that your monthly fellowship will not be released due to your continuous absence from your laboratory. For reference, please check DPPC meeting minutes in this regard. So in February itself, he was intimated of 2018 that his monthly fellowship will not be done, released because 4.3, 4.4 requirement is not been fulfilled by him. Now, my lord will come to this allegation that there was a change in application for change. That point, my lord. Now, first, before going to that point, my lord, let me read the IIT rules with regard to the change of supervisor. Now, my lord, before going there also, let me produce this document, my lord. Now, even though, my lord, it was projected that there is only one supervisor, the petitioner, that is probably not correct, my lord. There was two supervisors of the petitioner, my lord. And my lord will see now. Part of another document, my lord. So in his SOS seminar, my lord, so there was somebody called Lalit Mohan Pandey and Kalyan Rai Dongia. I'll give a better copy of it. I have one copy right now.
So is it part of your record?
No, my lord, it's not part of my record, but it is. I'm relying upon it because, my lord, this is important to show that there were two supervisors were there. If my lord wants, I'll produce the original copy of this record also. No problem. My lord will allow me to produce the original record. So there are two supervisors. My lord will see that the bottom, my lord, the signatures are there. Kalyan Rai Dongia was also there, and this Lalit Mohan Pandey was there. So, not if there is, he might have some grievance against the, I understand, but there was no reason for him to not to continue with work. He could have changed his supervisor also. That is now, my lord has seen this point, my lord. Now, my lord, let me address the issue of supervisor change. Before that, my lord will come to page number, point number 6.1 for a moment of the ordinance.
Yes.
Supervisor. Every student admitted to the PhD program undertakes research under the guidance of a faculty member of the department center in which he is admitted. My lord has got that line. The faculty member is called his supervisor. Full stop. Now, my lord,
So kindly continue. In case of an external
external.
category,
he is not an external candidate.
yes, a second supervisor is permitted only in case of an
But
external category.
No, sorry, my lord. That is what, my lord. That is what a misinterpretation in this case. As because in this case, there were two supervisors were there. That is my instruction. If the original record is required, I'll produce, my lord. No problem on this part. He is not an external candidate. Maybe because of the issues which he was raising, IIT would have appointed another supervisor. Now, my lord, with regard to the point 8.1, my lord will turn to the next page. 8.1. Change of supervisor. My lord, this point is the contention which my lord has been probably trying to see whether the supervisor was required to be present or not. And if present, in what capacity he was present. My lord, that also, my lord, is required to be examined to the honorable court. Now, point 8, these are only 3 situations which can happen. 8.1, my lord, if a student has only one supervisor and supervisor goes on a leave for more than 15 months, another supervisor is appointed with the mutual consent of both the student and supervisor is taken in such case. 2, if the supervisor of the student is an external category. So this is not related to us, my lord. Point number 8.3. Chairman of the Senate may permit a student to change his supervisor for valid reasons. In this case, there was no valid reasons by him. Mutual consent of the student and supervisor and recommendation of DPPC and IPPC are required. Such cases are reported to the Senate. It is an extreme case, my lord, where a supervisor is allowed to be changed. I do not know why the parity has been drawn between him and some other student. That student is not before this honorable court. And that student has completed his degree program from IIT, and other students have also completed his degree program. I am not privy to as to why that may be separate issue, my lord. But this is not the same case. There may be some other reasons, there may be some other valid reasons which could have triggered that change. In this case, my lord, the chairman of the Senate can permit only. Nobody else can permit it. And while doing so, it has to be for valid reasons. Consent of 3 parties are required on that case: student, supervisor, and recommendation of DPPC. Now let us look, my lord, the records now for a moment. My lord has seen 18.3. Now, my lord, will turn to page number. See what are the communication, what are the things which is happening. Now, my lord, will turn to page number 205 for a moment. 1 minute. So before going there, my lord, for a moment 202, my lord, will take a note. Page number 202. So from February, my lord, as my lord is seen that from January onward he was absent. No explanation, nothing is provided. Why he is absent for 1 year? No explanation. So page number 202 on 2/19 means February 19, 2018. So Noendeka has been intimated that you are absent from the lab for last month, not performing your proposed experiments. Neither you have applied for any leave. Meet and discuss urgently. Lalit Mohan Pandey. So Lalit Mohan Pandey, the respondent number 4, first, as a matter of he intimated after your SOS seminar, you have not come. Please come and meet. But for some reason he was not meeting you or whatever. Now it will follow, my lord. What is the reason? Now, my lord, will turn to page number 205. My lord has seen DC what is the role of DC, what is the role of supervisor, my lord has seen that. In the ordinance, my lord has seen, the supervisor has a limited role. Limited role with regard that doctoral committee is the committee which will ultimately will judge, my lord has seen 19.1 and also my lord 13.1, that it is the doctoral committee, my lord, which will ultimately will judge that whether your SOS seminar, doctoral committee, SOS seminar in 12.1 will be presented to the doctoral committee. It is the doctoral committee who is supposed to see. Your progress report is supposed to be submitted to your DC. Now, when there is two supervisors were there, maybe there is somebody else was also there. His signatures are there. But why progress report has not been submitted? Why so long as he has been absent? No explanation. My lord will now look to page number 205. Meeting of doctoral committee. Now, doctoral committee is the first body, my lord. There are three bodies here: DC, then DPPC and IPPC. With regard to the academic affairs, my lord, meeting of the doctoral committee, Sunayan Deka, roll number Iman, PhD student, was PhD was held on March 7, 2018, 4 p.m. in the conference room of Department of Bioscience and Bioengineering. The matter related to the absence of the student from the laboratory and his request for the supervisor change was discussed. The detailed academic particulars of the students are as follows. His performance in the written test, 30 out of 200 men. Brilliant student as well has been projected. His first choice of research area during interview of bio such and such was, his joining was in January 2016. Date of completion of comprehensive exam on 13/7/2017. Date of completion of his SOS was 13/12/2017. Following his SOS, the student is absent from the lab since 5th January 2018 and not performing of his proposed experiments. DC intervened. DC being the body who is been entrusted for his evaluation, intervened. Academic institution, my lord, has to keep this thing in here, my lord, consideration. DC intervened with the student and listening to his opinion. DC also took records of the opinion and suggestion by the supervisor. DC recommended following thing. Supervisor change is not accepted in this case as the committee has found no valid reasons for the same. The student is advised to join his laboratory immediately and start his proposed experiment. Student is advised to write an apology letter to the supervisor and HOD of PhD. My lord, will see in case of an academic institution, sometime if there is wild allegations have been made against principals, my lord, or any other institution, you say sorry to your principal and then go forward to close the matter. That did not happen. Turn to overleaf, my lord, page number 206. Now, my lord, meeting of DPPC was held in April 2, 2018, 12 p.m. in the conference room of Department of Bioscience and Bioengineering. The meeting was chaired by the head of Department of Bioscience and Bioengineering and list of particular. Meeting was chaired by the departmental of head of the department, my lord. No role whatsoever of the respondent number 4. Point 1.3, Sunayan Deka. This DPPC meeting was conveyed by the chair. So the chair, that is the head of the department, had convened the meeting, not the DPPC secretary. He, being respondent number 4, had no role in convening or whatever. DPPC meeting was convened by the chair, by the head, BESBE, for the agenda item. The DPPC listened to the student and recommendation of DC and closed was also discussed. It was decided that in absence of any valid academic reasons, now, my lord, is this court, my lord, can go into the reasons, not whether those reasons are valid or not at this point of time. Because if the my lord is trying to substitute the view taken by the DC and the BC and BSB, my lord will be stepping into the shoes of them, my lord. Which I humbly submit.
No,
my lord, my lord,
if
it is
the
probably-
decision is taken in contravention of the principle
That
of
is not been
national
done,
justice,
my lord. That is not
definitely
been my submission,
this
my lord.
court
That
will
is my
interfere with the same.
My lord, that is not been done, my lord. he was been heard. The BSBE has heard him. It was decided that in absence of any valid academic reasons and NOC from his supervisor change is not allowed. The student was recommended to continue his work in his laboratory and was asked to submit his respective progress report from his supervisor to release his fellowship. For that matter, for a moment, my lord, let me go to this extent and say that IIT did not at the beginning did not agree. IIT thereafter given him an opportunity, my lord, also to change the supervisor. He did not do so.
When?
That is what, my lord. I'll come to that. Now, my lord, will see page number 260. Next page. So after the DPPC meeting was done, what was the details of the meeting was intimated to him also, and he was asked to follow through. There was no progress on his PhD program. There was no progress. Page number 268, my lord. Sorry, 208. I'm sorry, 208. Page number 208. So on April 17, 2018, a mail was sent to Sunoyan Deka from the BSBE office. As per the instruction of DPPC secretary, kindly find the following information. My lord has seen that line. With reference to the appended email, I am directed to advise you to submit the compliance report of the DPPC. So DPPC had asked him that you submit a compliance report, that you join back the laboratory. Why he was not joining back the laboratory? Not performing his duties. DPPC recommendation report of DPPC compliance report of DPPC recommendation to the department office duly forwarded by your supervisor on or before 23rd April 2018 for the further necessary action, that is release of fellowship, etc. This is issued after approval of HOD and PSB. Few days before, my lord, that is on 10th of April 18. Dear student, as per the instruction of DPPC secretary, kindly find the following information. You were advised to comply with the following DPPC recommendation as per the resolution in the meeting held on 4/2/2018. The request for supervisor change was not allowed by DPPC in absence of any valid academic reasons and also NOC from the supervisor. The DPPC recommended continuation of your work in your laboratory and submitting the certificate progress report from your supervisor for the release of your fellowship. Turn over list, my lord. Thereafter, my lord, his professor writes to him on 14th of May that as per meeting with the HOD and subsequent meeting with your lab members along with the father, they again try to make it so that the petitioner's life is not wasted, my lord. They again and again they have tried to bring him back with the folds of education. You agreed to apologize. And such thing is happened. Thereafter, my lord, we'll see page number 210. So meeting of doctoral committee, again, doctoral committee meets on 21st of 2018. Meeting of doctoral committee of Sunoyan Deka, a PhD student of PhDs, was held on 21/5/2018 at 5 p.m. in the conference hall of Department of Bioscience Bioengineering. Initial request of Mr. Deka for the change of supervisor was declined by his DC on 7/3/2018 in absence of any valid reasons, and his further request for the same was declined by the DPPC on 24/8/2018. Despite joining back to his work, he wrote to the higher authorities of the institute stating that false allegation for the change of supervisor. Even after his behavior, supervisor allowed him to continue his PhD work in the lab concerning his academic career, but the student himself declined to join the lab and resume his work. Further, as per the advice of the competent authority, DC meeting was organized and matter was discussed. DC members advised the student to hand over the laboratory records and obtain the no due certificate before considering his request for change of supervisor. the student was asked to comply. So, my lord, his supervisory change request was agreed. Ultimately, he was asked to do this, that you submit your lab records, because if this lab records are required to obtain the NOC. For some reason or other, I could not find this, I could not find that. That is the reason he is giving a PhD student whose job was to research. He could not find his journal, and some or other reason he is cited, and he did not comply with it. So, my lord will find fault with an IIT in this case, even though that option was given to him to change the supervisor, provided you submit your appropriate records so that change can be taken place. That he did not do. He had read some mails. My lord has seen that mails. I do not want to waste the honorable court time on that. To reading.
No, can after going through this paragraph of this minutes, it can be said that you have given the offer to him.
Yes, my lord, it was. It was, my lord.
Before considering his request for change of supervisor.
Because this has to be read with the emails which are read, my lord. Now, if the emails have been read, it will become clear that the offer was given to him.
My lord is just pointed that question. So if I may just respond, because he has been constantly saying that, lordship, certain submissions that I was not aware of, such as 2 supervisors, those are not part of pleadings. That is not part of PhD ordinances that I can have 2 supervisors. He is saying that the DPPC meeting, my lord, he is at page number 210. Lordship will kindly see below page number 210, the signature Dr. Lalit M. Pandey. So this is the signature of Lalit M. Pandey. Kindly see the DPPC meeting minutes also, where he is justifying that the DPPC minutes, he was only there as a guide. Constantly, my lord, he is making these allegations. Page number 207, where
What is
page
it?
number 207, the sign below, that is again of Lalit M. Pandey.
Why did
He
he
is
get
sitting
this
as a
idea?
judge and he is passing
How
orders.
did we come to this idea, my lord?
Please see
Is this
210.
DPPC is only one member committee? Is this the submission, my lord?
Please see page 210.
Is
The
this the
signature
submission?
there.
Is this the my learned friend is an expert in signatures, my lord. I am not on that. But DPPC is not a one member body, my lord. I will now show the DPPC comprises whom against who are the people. But let me address this query first, my lord. The my lord's query, that whether this change of supervisor was accepted or not. Yes, the answer was yes, my lord. As a matter of advice by the competent authority, DC in the meeting organized a matter and discussed. DC member advised student to hand over the laboratory records and obtain no due certificate from his laboratory before considering his request for change of supervisor. So he was given this option for change of supervisor. Now, my lord will see his email is a part of the case relied upon, my lord. He is read out from the petition. Page number 88. For a moment, man. See, my lord, in this mail itself that which I was reading, the page before in 209, the option was given by the Mr. Pandey that you take an NOC from me. You have agreed to apologize. You were suggested both the options, either to join back my lab or take NOC. You were further did not meet me since more than 3 weeks, despite several calls. You need to help yourself. In absence, I am unable to help you. For getting NOC, you need to take no due certificate from the laboratory and submit an application for the same. Thereafter, this request was considered by the DC, and DC said that on the advice, because they wanted to allow this student to to further his studies. Advise the student to hand over the laboratory records and obtain no due certificate from his existing laboratory before considering the request of laboratory for the supervisory change. Now, my lord, he has written back, he has given some explanation. He has lost the book and whatnot. My lord has seen those emails. I don't want to read through. Now, if you do not follow the requirements for the NOC, can the NOC be granted? You never met, you did not come, you did not do anything. And then you make an allegations of all those that it was prejudice. Now, my lord has seen member of DC member as per the my lord, my the point number 9.1, my lord. Supervisor is a member.
So,
of the DC.
Mr. Day, after going through this email at page number 209, annexure R14, it appears that Mr. Pandey has offered to obtain NOC from him.
Yes, my lord. He has told me multiple times you come and take NOC. And he made, I have read out those emails, that is why. That I would give him everything, but he would not give the
Then
NOC.
why you have not complied with that?
I have, my lord. That is why I am.
Yes.
Please see page number 55, my lord. This, I have read this
Of
already.
your pleading.
Yes, my lord. 58. These are continuous emails. Please see page 58. This is in response, my lord. As per your. May I read, my
Yes.
lord?
Yes.
As per your directive, in order to get my NOC for supervisor change and no dues from laboratory, I am hereby attaching the datas of my research work. I want to apologize for not giving the datas in person as per your instruction, as I was not feeling well and had to consult the doctor for the same. I will be forwarding the remaining datas from my private mail as I have limited space in my institute mail. So all datas he gave. There was one notebook that he had lost. So the supervisor said, you give me that notebook also. So in that regard, next page, my lord, kindly see page 59. With due respect, I want to state that as per your directive in the DC meeting to find out my lost lab notebook, a Jaldhara notebook, in order to get NOC for supervisor change, I tried my best, but I apologize for my inability to find the same. Thus, I will be very grateful to you if you suggest me an option to get my NOC from you. So I did everything, my lord. I could not give a notebook that I had lost earlier and that was specifically he asked for that notebook. And it was my notebook. He's asking, it is unethical. He's asking for my research work. Anyway, my lord, in the other case also, he wanted one notebook that I lost. Everything else I had given.
Everything is deliberate on my
But
part.
after this, let him show anything that, okay, your notebook. I
Let me
am
on that
allowing
question,
the
if this
supervisor.
is the question, whether there was a sufficiency or not, then my lord will allow me, I will produce the record whether there was sufficiency or not. Now, my lord I will come back to this point again, my lord. Before completion that chain of thought, my lord had asked whether the co-supervisor was part of my pleading or not. My lord had asked this question. And my learned friend jumped up and said, this is not part of my pleadings, my lord. My lord will turn to page number 353 for a moment.
Page number?
353. My lord has got it. Yes, we read this paragraph, my lord. 9. I'm not reading the top portion. My lord has seen. In the between of the page, it is to be the petitioner had submitted an application for change of supervisor, which was a procedural matter. First discussed in doctoral meeting along with the petitioner. My lord has got that line. It is to be stated that the objective and direction of the work to be pursued for PhD thesis. The petitioner already approved the doctoral committee on 13/12/2017. A line led there from another. A co-supervisor from another department was added to help the petitioner. I have produced the record only. So my pleading is there a co-supervisor was there. And this has not been replied, not been denied. Whether there was sufficiency, the requirement for issuing an NOC is lies on the supervisor. Now, tomorrow, if he loses some, there may be some data, there may be some other requirements, we do not know this. We have specifically made this, but this point was never agitated, my lord, that way. Otherwise, the respondent number 4 may be asked. My lord will see whether the NOC could have been issued as per the rules or not. If my lord wants to go to that debate, my lord will turn to the next page, my lord. Page number 354. DPPC comprising how many people? Bold, my lord, DPPC comprising 9 faculty members, 1 faculty chairperson, and 2 student members also. So the decision in DPPC, my lord, which has been projected that it's been solely taken by me, I have influenced somehow only by my mere presence, because my mere presence is required as per the statute. I am supposed to be heard. They cannot take decision without hearing me, because my consent is also required. There are 9 members, 1 faculty chairperson, 2 student members were there. So this is not a case, my lord, where DPPC's decision has been somehow been colored by the only presence of the supervisor. That, my lord, I humbly submit, my lord, with utmost respect, my lord, that is a wrong assumption. We converse with the petitioner side at the beginning itself.
No,
Let me-
but if your presence in the meeting raises suspicion in the mind of the petitioner that he will not get fair justice in the,
I was not
meeting.
hearing the meeting, I was not here.
then definitely
My lord, on that case, my lord will see. My lord
he
will
had
see.
succeeded in
My lord,
making out the case.
accuser will not be allowed to face the accusation, my lord. If I am not supposed to face my accuser, my lord, is this the natural justice principle, my lord? If an accusation is made against me, it was to be decided without hearing me, my lord. Is this the law which this honorable?
No.
Then
That
this is what has
no,
happened, my lord. I was
the-
hard there only.
the committee could have heard you in his absence. in
It might
absence
have
of
done
the
it, my
petitioner.
lord. It might have done it. The committee might have heard him in my absence. We do not know this fact. These facts are not before this honorable court. So what I am respectfully again submitting, my lord, this entire canvassing of the story that there was a bias pre-existed, which resulted into this thing. This is incorrect, my lord. The point which was not responded very carefully by the petitioner side is this one, that he was absent from the lab from January 2018 till he was terminated. No reasons whatsoever, nothing, no silence, absolutely silence. Second, he was not performing. There was no progress report submitted to the DC after his SOS seminar, my lord. So therefore, my lord, power under 16(1) can be invoked by the IIT to cancel the registration. It is a case I will now demonstrate, my lord. I will also show that before doing so, before cancelling his the list was published, my lord. It is a matter of fact in the website of IIT. Date is given there. My lord will see this list. These are all PhD students who are supposed to meet and complete their due requirement. My lord will see the date in the bottom. It was published in the website of the IIT. Point number 2, list of debar students for January, May 2000 for due to pending requirement of the PhD program. Point number 2 is Sunayan Deka. This list was published on 9 January 2019, my lord. In the website of the IIT, the website details is also there, my lord. He was aware, my lord, all throughout, my lord, that he will be debarred. There will be some action will be done against him. He never ever tried, my lord, before IIT to console to come back to the fold for whatever reason, right? So that may be his personal grievance, my lord. But DC had nothing to do with this, my lord. So, my lord, what I am submitting, my lord, must be taken from the
Okay, 5 minutes.
after 2 months.
But you see, if the petitioner is interested to pursue the program again, can a lenient view be taken on the part of the respondent?
My lord,
You
on that
obtain
part, my lord, I have
instruction.
taken instruction, my lord.
You obtain instruction.
My lord, right now,
We resume at 2 o'clock.
my lord, if it is only convenient only on this part, my lord, I will complete my argument. because my lord, my standing counsel is actually my lord, my senior. He can write to IIT, my lord. I am one of the,
No, verbal instruction you obtain through your senior.
my lord, I'll indicate my
Okay.
senior. I'll,
You inform the court at 2 o'clock.
my lord, I understood what is my lord
Because
is happening.
nobody will be gaining.
Yes, my
nobody
lord,
will
I
be losing.
appreciate what is calling from the, I'll ask my lord, I'll ask my lord.
Lordship,
Yes, madam.
I am not feeling well today, Lordship. I am
Yes.
for item number 10, Lordship.
Item
For
number 10.
PTC, Lordship. I have taken question from other side, Lordship.
Okay.
Lordship, may pass over for the day, Lordship.
Item number 10.
10.
Go for BTC.
Yes, Lordship.
Miss, your good name, please.
RB Bora.
RP Bora, learned standing counsel for BTC with consent from the other side. Thanks for listening the matter. After? When? After a week. Fair enough.
Item number 3, to continue.
Lord, my lord had asked me to take instruction, my lord.
Pardon?
My lord had asked me to take instruction, my lord.
Yes.
I had spoken to my senior and then accordingly he has also spoken. My lord, a day may be given, we'll be coming back with the instruction because the
Date.
one day may be given, my lord, just one
One
day.
day.
And any on Tuesday, my lord, we will fix it because I think and then probably the officer concerned was probably, sir, was my senior was not able to reach. Any day on Tuesday will be given, my lord. If it is a part-hard matter, we'll come back with instruction, my lord.
20, Lordship. Next Tuesday.
Yes, Mr. Day.
Lordship.
I have emphasized, my lord, what my lord has been as calling from the court. I had told them this on this point.
If he genuinely want to pursue the matter, pursue the PhD, then let him give us some.
Yes, my lord.
Heard Mr. S. Day, learned counsel for the petition, and Mr.
AB Day,
A.B. Day, learned counsel for the respondent.
IIT, my lord.
IIT.
And
Heard in part, or leave the matter. And Mr. S. does for the number 4. Heard in part, leave the matter on 20th as part heard.
Much obliged. Item appraisal, item number 24 and 25. Item 4. Item 4.
May please, your Lordship, Lordship, this matter, my lord, same connected two matters. My lord, Mr. P.K. Bora was appearing in this case, my lord. There are two matters, my lord. The same petitioner, my lord, has filed them in the previous occasion. That has not been, my lord, projected in this current matter, my lord. It is WPC 6486 of 2008.
Six.
6486 of 2008 and 1634 of 2007. So, my lord, these two petitions were earlier on, my lord, done by the same petitioner, and it has bearing in this case, my lord. So, my lord, those two cases may be tagged with this case, my lord. So that, my lord,
Whether those matters are pending.
those matters are not pending, my lord, but those matters are, I have been informed that those matters have a bearing in this case because it was regarding, my lord, arrear as well as that his termination. So it's regarding arrear salary, my lord. So, my lord, my prayer will be, my lord, that these two matters will be taken up with this matter. Then, my lord, the records of those, it will be in the disposal. WPC.
My case is different.
My lord, those,
I'm going to,
my lord,
after completion,
I have been instructed by my lord, concerned colleague, my lord, that these two matters will be tagged together with this, so that because that those two cases also have a bearing with this case. Mr. P.K. Bora, my lord, he has instructed me, my lord. So, my lord, we'll fix it, my lord, in the next week, any day, and my lord, we will along with these two cases, and then my lord will the picture will be larger,
No, this matter is of 2022,
my lord.
and the other matters are of 2007 and 2008. And how those matters?
No, my
are
lord,
related
because
to the present?
he's claiming, my lord, he's since the respondent authorities have not released, he's claiming his monthly salary
Not on that, my lord, I am going to
since
satisfy.
2007.
Please move,
My lord.
move side
So, my lord,
audio. Problem is that, my lord,
that is why, my lord.
my case is totally different.
Same
And
petition.
same appointment, same select list, same appointment already decided by this coordinate bench of this honorable court, my lord. So I am pressing later on, my lord. First, your lordship go through it, my lord, in my argument, my lord.
Lordship,
No, no, Mr. Bora.
My lord.
So, you have filed these two petitions.
earlier,
My lord.
You have filed these two petitions,
6486,
686.
6486 of 2008 and 1634 of 2007. That is what Mr. my lord have been instructed, my lord.
No, not only that, man. That was one of
No,
the cases,
you first answer my
my
question.
lord.
Whether you have filed these two petitions or not.
I'm annexed the order, my lord. Your lordship go through it, my lord. Page 31, my lord. Page 30 onwards, my lord.
No,
2865
this is a different case, my lord.
2865 of
This
2010.
is a different case, my lord. This is 2010, my lord. What I am referring to is a 2008 matter and a 2007 matter, which is prior to filing of this case, my lord, which he has annexed. So therefore, my lord,
My lord,
my
there-
humble
there is
submission is,
a-
my lord, a hearing date may be fixed, my lord, but on these two cases may be tagged with this case, because that those two cases, according to my lord colleague, has got bearing in this case.
Is there any document?
Because my lord, he has.
Place the,
No, I have given the. I have
no,
given
no,
the-
you have placed
I
this copy.
I have given.
Online, you have the, everything is
I
there.
have given the case number.
Oh, that is why.
That is why I'm asking.
There
my
is a
lord.
case,
I have
contempt
given-
case is pending. I am not on that. I am on the after all order passed by lord, they accommodate us by giving me the scale, but they giving the new pension scheme, my lord. So I am challenging that point, my lord. And that was decided, similarly decided by the
My
coordinate
lord,
bench.
the same petitioner has filed.
Maybe, may not be.
Six four eight six of 2008. রেকর্ড করবে ডিসপোজাল কি বলে 12 বছর হয়েছে অনলাইন
So these records are not available.
No,
in the-
lordship. The online version, the online has come after 2012. So in the disposal section, the record will be available, my lord. The record is available. So my lordship will direct to bring those two records. That is what my colleague has, my lord,
That is on
prayed for. And my lord, the 2012, after 2012, the digitization has come. That is why the till 2012, your lordship will find 11, 12, your lordship will find the online
So
orders.
why he has filed an
But-
affidavit,
but-
why didn't mention, not
My
mention
lord,
before this? my lord?
I have been instructed, my lord, because subsequently it has transpired that these two petitions was not disclosed by the petitioner, that these two cases were filed. Subsequently, it has been discovered that these two petitions, the same petitioner, Jyoti Pegu, has filed. And my lord, that is regarding salaries and all that, termination and arrear
That was
salary.
disposed of.
So my lord,
I'm annexed it.
so my lord, the one which he has annexed is 2010, 2865 of 2010. So these two, my lord, since I have been instructed by Mr. P.K. Bora to kindly, my lord, convey to the court that these two petitions formally are pending.
Okay, let the record of these two petitions.
Yes, my lord. Simple, my lord. That's it, my lord.
We'll see.
Actually, my lord, that is in from 2007, my lord, they stop my salary. And this is after honorable court's order, they accommodate me. That order, one of the cases was disposed of and accommodate me by not giving the new pension scheme, old pension scheme. Now I am challenging that perception.
So
What
that's
is
all right.
honorable court?
We'll see whether such kind of error was there in the earlier two petition or not.
Maybe, my lord.
If
My
that
lord,
was
they
there,
filed an affidavit, they did not mention anything, my lord.
at that time, it may not be in their knowledge.
Case number 2, dear.
Art Mr. and Bora, learn it. If
I'm for 1 to 6, 1 to 5.
respondent number
1 to 5.
1 to 5. Mr. Pokok submits that the petitioner has had filed earlier two other writ petitions being WPC number 6486 of 2008 and 1634 of 2007.
My lord,
And
one
to-
is 6486 of 2008, 6486, and the other is 1634 of 2007.
2007. And to adjudicate the present dispute, record of the aforementioned to adjudicate the dispute in present petition. The record of aforementioned two writ petitions are required, and as such, a right for calling those two record of those two writ petitions. Before hearing the matter. Accordingly, it is provided that residents shall take the WPC number along with this writ petition and list the matter for hearing.
Well, along with WPC numbers 2865 of 2008.
That order is there.
2865 of 2010. That disposal matter is also recorded because that was there, I think. 2865 of 2010.
Why that is necessary?
Because of that was disposed of. We are challenging that termination order. Court, honorable court, all are mentioning that matter. 2865 of 2010.
No, that order is available before this court.
Yes,
But
ma'am,
all
yes.
annexures are there. I think everything is there in the
Necessary
petition,
will call it,
my lord. 2865 of
so
2010.
not today. Later on, we will call for if necessary.
No, my lord. He says that, but that record is also necessary, but other all.
No, that order is available before the
Yes,
court. After 2 weeks.
Item 5.
Well, that may be fixed, my lord.
Item 5.
We have filed our affidavit today.
Today,
Yes, my lord.
is
This
it on
not-
the record?
Not on record, my lord. My lord, affidavit has been filed. Today, my lord.
In the morning, you could have informed this court, then we could have called for it for the second.
কি করতে হবে? পরিবর্তন।
Okay.
They are not ready to.
Heard,
Uh,
miss?
As J Das on behalf of Ardhar.
Learned counsel, appearing on behalf of Mr.
Ardhar.
Learned counsel for the petitioner. And also heard Mr. S.R. Rava, learned pending counsel for petition. Mr. Rava submits that he has filed his affidavit in opposition today morning. And the same is not available on the record. Accordingly, it is provided that Jessica lists the matter on
Lordship on 14th.
19th, along with the affidavit in opposition filed by the respondents in BTC.
Hello.
Here in this matter, on the last date, Mr. S. Das was supposed to get the updated instruction. Lordship, I have been informed by him that Lordship updated instruction is yet to be received, Lordship. So Lordship, may I pray for a week's time, Lordship, in this matter, Lordship?
This is not the law, your
Oh, my
lordship.
lord.
If after repeated orders by this honorable court, affidavit is not submitted, then my lord, we have to follow Nasim Banu's case, my lord, reported in IR 1993-2572, your lord. Assuming that the statements made in the writ petition are correct. So that is the thing, my lord. How long, my lord, they will take? First order you have, your lordship has seen. Second order, my lord, your lordship has passed. But despite all this, my lord, 8 respondents, nobody is coming. Now, the case relates to, my lord, the selection for appointment to the post of the assistant teacher, my lord, in a college. Namely, my lord, Pandit Dindayal Upadhyay Mahavidyalaya in Karimganj district, your lord. Assistant professor, my lord, for the. My lord. Now, my lord, your lordship may kindly see, my lord, turning to page 120, your lordship. Your lordship may see the.
You tell me, can we hear the matter without their affidavit?
Now, my lord, then my lord, it is.
Lord, how long it will take time, my lord, for filing there? How long we will wait, my lord? Your
Yes,
lordship,
yes.
kindly see, my lord, the earlier orders, my lord. My lord, when they have received notice and thereafter, my lord, how many dates has been passed by, my lord? But they did not respond to it,
The
Now-
past order was passed on 4/12/2024.
my lord.
Second
Thereafter-
order was 24/3/2025,
Correct,
and the last order was 23rd/4/2025.
yes. The number of occasions, my lord, for opportunity was given to them to file affidavit in opposition, but they didn't. my lord. Now, your lordship on the other day, last occasion, particularly, my lord, uh, uh, ordered, my lord, to submit, if any, my lord, the affidavit in the meantime, my lord. But today also they did not file. They are taking time, my lord. Now, considering the urgency of the case, my lord, your lordship kindly see, my lord, from 2023, the matter is pending. 23 was the, my lord, the advertisement and the selection process, then. my
No,
lord,
but
process
you
started in
approached the court only on 4/12/2024.
Now, my lord,
No, my lord, prior to that, my lord, September 2023, my lord, we came. Then again, my lord, there is an order passed by this honorable court asking them to furnish, my lord, the records, my lord, which we have applied for RTI. My lord, that has been furnished to us. Thereafter, we filed this second, my lord, round of litigation, my lord, in the on 12/2024, December 2020. Now, my lord, the fact remains that there is, my lord, absolutely, my lord, my lord, urgent in the case because, my lord, the person who has been recommended for appointment, my lord, to the post is absolutely, my lord, not eligible for appointment to the post. That my lord, my senior, learned senior will demonstrate as to how arbitrarily her name has been, my lord, recommended for appointment to the post. In violation of, my
Whether
lord, the
whether
guideline,
any stay
in-
order is operating.
my lord,
Is there any stay order?
there is no stay order. That is why my lord, the difficulty at any point of time, my lord, they may appoint, my lord. That is why. Now,
This
my lord,
petition,
in the
lordship, only in the
meantime, your
month of
lordship,
December
in the meantime,
2024,
your
lordship.
lordship may
Hardly,
kindly-
lordship, 4 months old petition, lordship. I am seeking for 2 weeks time, lordship. I'll get the instruction, lordship, because
No, 2 weeks time, how many times you have
yeah.
in the meantime availed?
matter is 4 months old, but we have got time twice.
my lord, your lordship may
No,
kindly.
are you genuinely interested to
Yes, lordship.
file the affidavit?
Yes, lordship. A date may be fixed, lordship. We'll file, lordship, before the next date. lordship.
No, by my lord, I'll be going back, my lord.
But
Staying up to here, my lord.
you have to ensure that no appointment is made in the
16th, your
meantime.
lordship, I am here. Up to
My lord,
16th
yes, your
of
lordship may kindly observe, my lord,
Lordship,
that, my lord,
lordship,
no
since Mr.
appointment
S.
could be
Das is
made.
looking
in
No,
the-
no, I am not passing any such order, but
Right.
he has to assure that.
lordship, that I will communicate to the department, lordship.
No, not, you have to
Every
ensure
time,
that
my
no
lord, they are
appointment is
saying this
made.
thing, my lord. Department, other
Lordship,
than
let a date
department,
be
my lord,
fixed, lordship.
department, other than department, respondent number 8 is there. Who has been selected for appointment to the post of the assistant teacher in a college. Now she is also not coming because she knew that for some extraneous consideration she was appointed. She is over it.
Okay.
She do not have PRC, my lord.
My lord, your
Mr.
lordship,
And
And
all these things, my lord, these are all arbitrary in nature, your lordship. So, my lord,
Okay,
if they
okay,
do not
let
file
them
the,
do
my lord,
the petition.
affidavit,
Let the affidavit come or within a
and
very
my
short
lord,
period.
these guidelines of the Supreme Court is to be followed, your lordship.
Okay, definitely we'll.
Nasim Banu's case, your lordship. Everybody knows.
And also heard Mr. Upamanya, learned counsel for the
Respondent number one and two.
respondent number
1 and 2.
1 and 2. Mr. Upamanya submits that. Mr. S. Das is supposed to obtain instruction and to file affidavit in opposition, but Mr. Das is out today. He is not present.
Lordship, he is on lakes in lordship, court number 2, lordship.
he is in port number, he is busy in port number 2 and he could not file the affidavit in.
My lord, date may be given prior to
Time.
16th, your lord.
However, considering the facts and circumstances and also the urgency of the matter, 1 week time is granted to Mr. Komina to file his affidavit in opposition. In the event of failing to file the affidavit in opposition on next step, the court will proceed to hear and dispose of the matter without the affidavit of the respondent number. So place the matter on COVID.
15th,
On
15.
before 16, my lord.
15th,
Let it be on 15, my lord.
15.
1-5.
1-5.
Lordship 15, Lordship, can it be Lordship?
Prior to 15 যদি হয়
Can it be in the next week after 15th, Lordship? Because there are holidays, Lordship.
No, my lord,
21st.
my senior will be leaving, my lord, will be there up to, my lord, 16. Therefore, my lord,
Since,
can
Lordship,
it,
I have been given one last opportunity, Lordship. That's why, Lordship, I am seeking.
And for, my lord, doing this case, I had to come from Delhi, your
there will
lord.
be, my lord.
No, if it is not on law point, you are not required to come. Mr. Sen can argue the matter.
But
Or you can join through VC also from Delhi. No problem.
Let it be on 15th, your lordship. Enough time they will be getting. Today is 8.
Lordship, we have to get the
Today is
instruction
8.
and then
And if it is not possible, then on 16. If it is not possible on
It is on
15, then
16 of-
16. 15 would be better, your
16.
lordship.
Okay, 16.
16th.
1-6.
Oblige.
Respondent number 3.
oblige.
24, 25, contempt.
Met please, your lordship. Lordship may kindly peruse page number 56 of WPC number, lordship 3093, item number 24, lordship.
Page number?
Page number 56 of the writ petition, item number 24, lordship. Lordship, will get that this is the communication issued by the Director of Secondary Education for resubmission of proposal creation 23 post, lordship. Lordship, get serial number 3, lordship. Contempt petition number 194 of 2022 in WPC number so and so filed by Bhairav Kumar Medhi and 12 others. Lordship, I have given the communication, lordship, provincialization order in respect of this Bhairav Kumar Medhi and 12 others, lordship. May kindly peruse 2 of the order. I have just provided to lordship. Page 2, serial number 1, Sri Bhairav Kumar Medhi and 12 others, lordship. So similarly situated persons have already been provincialized, lordship. And my name appears at serial number 4 and 5. In page 56, lordship. I'm sorry. Page serial number 4, contempt petition number 127, 576, filed by Omar Ali Sheikh, lordship. That is the item number 25. And next, serial number 5, lordship, contempt petition number 122, 28 of 2022 in WPC 2543 of 21, filed by Abdul Ghafoor. And Abdul Ghafoor is the present petitioner in item number 24, lordship. So similarly situated person have already been provincialized long ago, lordship, 24, lordship. I am holding the provincialization order of.
Okay, all right. What instruction you have received?
I have received from the Deputy Secretary and addressed to the Director, Secondary. Here clarification regarding the head of account for the proposal of creation of one post tutor assistant teacher in respect of Omar Ali Sheikh. Contempt petition number so and so in WPC so and so. With reference to the subject cited above and your letter under reference, I am directed to request you to clarify whether the proposal for creation of one post of tutor assistant teacher in respect of Omar Ali Sheikh falls under head account of head account within bracket H/A 99 or HA 98. In case of proposal under H/A head account 98 You are requested to submit a revised proposal accordingly along with the relevant checklist. As the matter pertains to contempt proceedings, you are requested to furnish the required clarification by 7/5/2000.
So now the question is it 99 or 98?
Yes, ma'am.
So these are the games you were playing. So being the director of secondary education, you do not know under which head the head of account is to be created. Mr. Sharma?
Around here, sometime maybe get around
sometime?
next
What
date, my
sometime?
lord, on next week, my lord, so that I can obtain the instruction.
This contempt petition is pending since the year 2024. Let the director remain present in the court.
Last
No
month,
other option.
kindly last chance given.
What last chance? How many last chance you have availed till date? Being the director of elementary education, you do not know under which head this account has to be created.
On the last occasion, as per my instruction, in this connection, it may be stated here that there is a budget provision of rupees 8,500 lakhs for the above purpose during the financial year 2005, 2025-26. The expenditure is debitable under head of account, so and so 99, and last 99 is there.
In contempt petition, you take down hard Mr. R. Islam, learned from the petition. And also hard Mr. Q. Sharma, learned standing counsel for the contempt not. Contender number 1 and 2, both. Mr. Sharma? After hearing learned advocates of both the parties and also taking note of the fact that the order was passed in WPC number 2979 of 2023 on 3/5/2023. The contender number 1 and 2 are given the last chance to comply with the order of this court. Else to remain present in the court on next date, that is after 1 week
19th.
at 2 p.m. You comply with or remain present in the court. This is a list this matter along with WPC number 3093 of 2024.
As part happens.
Places will keep the matters. But
Bail hearing, item 7.
There are two bail hearing matters today, my lord, 7 and 26. Both the cases, my lord, issue is same. If possible, my prayer before your lordship, my lord, I do not know whether you agree or not, my lord. Kindly 6 days time may be allowed to me, my lord.
pardon?
6 days time may kindly be allowed to me, my lord.
You,
Yes, my lord.
why?
Actually, my lord, I'll have to go through some detail. My lord.
In
To
item number-
enable you to go through the decisions, you have been granted
need-
time till
I need-
today.
Yes, my lord. Sorry, my lord. Yes, your lordship has earlier, although earlier not took time, but my lord, one item number 26 is my lord part heard. So, my lord, on the next date, my lord, any date, my lord, after 6 days, my lord, on that day, I will not take any.
Why 6 days? Is
I
it?
need, my lord, some more preparation, my lord. Something I
Your
will have to
Lordship, that
system.
issue is simple, the whether grounds of arrest were communicated or not, that your lordship already has heard me on other day also. Only he wanted to go through
No,
that.
the question is that retrospective effect.
Yes, that constitution bench judgment which I have relied from Provi Prakash, which is relied, lordship, that he wanted to go through it, lordship. Apart from that, there is nothing, because that judgment is long, past long back constitution bench, lordship. And Provi Prakash is also there.
That constitutional bench decision is very short.
Yes,
Why you could not go through the same?
Yes, my lord, on that day, my lord, although here, I have gone through, but my lord, I will have to, my lord, some more clarity, I need some more to go through in detail.
and that confusion is already clarified in Provi Prakash
Your
judgment.
lordship may
also
kindly
that-
fix it on 14th, my lord, on 14th, I will not take any adjournment, my lord. I will finish on
Here in this case, only that issue, probably
14th
that
or
long
15th,
date
ma'am.
probably is not required. Apparently.
on Wednesday, my lord, of 43rd.
Otherwise, Provi Prakash is also clear, lordship, that is once, lordship, that grounds of arrest is not communicated, that he should be released forthwith. So, and today already this is the third date, lordship. Only that much.
My lord, for the first time, otherwise I took time, my lord, earlier.
But let him obtain.
I am in difficulty because now trial court also granting bail on the first day itself. That is the difficulty, lordship.
Pardon?
Now trial court also giving the benefit on the first day itself. That is my difficulty.
Go and approach the trial court.
Only short date, therefore I am paying, lordship.
No, you go and
So
approach
this
the
case
trial
is
court.
already pending before your lordship consideration. Lord.
Oh, we are
Yeah.
closing it today then.
That I am not paying, lordship. Only that much.
Mr. Portaker learned additional PP. Price for granting him some more time to go through the decision of the Honorable Supreme Court in the case of
Hari Kishan versus State of Maharashtra and others.
pardon.
Hari Kishan versus State of Maharashtra and others.
Citation.
That is 1962 supply. I'm sorry, lordship. That AIR, it is in AIR. AIR 1962 SC 911.
Prayer is accordingly allowed to list the matter on 14.
Can it be on Monday, lordship? Monday, Monday or
Tuesday.
Tuesday, lordship.
Tuesday, my lord, I may not be available, so my lord, fixing out
Wednesday, I will not be available.
on 14th, my lord.
All right.
Item 26. Item 8 orders. Item 8.
Eight, lordship, I have received instruction, lordship. The government has directed the registrar of the Dibrugarh University to release the lordship that area pension part, lordship, pension as well as area pension from the grants in aid, lordship. Grants in aid which was given by the government, lordship. If fund is shortage, then they have required to letter to the authority for release other funds. Otherwise, grants in aid is there, lordship. That's because there is no particular pension head. The university, Dibrugarh University as well as Guwahati University, all are run by grants in aid, lordship. This is the instruction. এখন দিয়কচোন।
ইউনিভার্সিটি পয়সা আছে জানো?
আছে।
My lord, to be honest, my lord, this is how things are going on for the last 5 years, 4 years after the judgment. Someday, my lord, contingency fund, someday they say we'll come up with supplementary grant, someday we'll say we'll earmark in the budget. So now, my lord, the latest instruction is grants in aid is already there. So from that, we should be paid. But I think I remember correct, if I remember correctly, on last occasion, on quite a few occasions, university expressed its helplessness that exist funding is not enough, good enough for the present thing. How can we undertake this additional liability?
It is the
Well,
employee
end of the day, it is not a question of, my lord, I mean, appropriation. It's a question of complying a high court judgment. It is in that view of the matter, my lord, government should take so some sincerity in the matter. It's a judgment of 2021. We are in middle of 2025. The people are dying. Members of the association are dying.
It is not a cash debt lawsuit. They are not getting the pension. They are getting only regular pension is they are getting lawsuit. They are the employee of the Dibrugarh University Autonomous Body lawsuit. The Dibrugarh University run by the lawsuit, the grants in aid of the government lawsuit. And they are now only issue is the regarding lawsuit area pension. Area some parties given lawsuit, other some.
Not a single paisa of area has been given. Not a single paisa.
Only area part is there lawsuit. Area part, so government has directed the registry of the Dibrugarh University to give them from the lawsuit the grants in aid lawsuit. That's because there is not particular head is there. Even lawsuit.
No, whether that instruction you have given to the university.
Already written letter lawsuit.
Where?
It is the letter lawsuit. It is first page lawsuit. 5/5/25 letter lawsuit.
So who is representing register? You.
I received it just now. I have to take instructions. Try to conduct the.
You just now contact the register. You
Yes.
this court after 5 minutes.
Yes.
Just try to talk to him. It's on my record. He cannot, he's whispering, I'm in an election.
No, otherwise he shall remain present in the court.
Huh.
You try to contact him.
I've got it just now.
No, that's all right.
No, matter can be called after 10-15 minutes. My learned friend can try.
Okay,
I tried to talk to him also now, just 2 minutes back.
okay, at 3 o'clock.
Yes.
So listen, he's in some training. He said, I cannot talk now. He was whispering in my ear. I tried to talk to him. I called him twice, not there. The moment I got it, I tried to talk.
He is trying to, even just I have, when I have delivered
Sent a
the.
message,
See,
they
yes,
sent a
right.
message, probably, I don't know if he has read it. Tomorrow, not it now, maybe.
Tomorrow and Monday, this court will not be sitting.
I got it now and he also hasn't got it. He's in some training.
No, better you do one thing. You ask the register to remain present in the court on next day,
Yes, on Tuesday next.
Wednesday.
But
Wednesday, he has to clarify whether he can pay this amount or pay the area salary from this head or not.
my lord, can I suggest one thing, my lord?
Yes.
Let somebody from the higher education department be not as a contempt notice. Let them assist the court, my lord, because these
No,
people
sir.
are.
Of the higher education, I will be there lawsuit. I will be even update instruction, I will be taking lawsuit. Persons is not required higher education lawsuit. That's because if lawsuit, if there is a violation lawsuit.
No. Tomorrow, my lord, because otherwise they will say we have written to so many. This is how things are going on.
Not lawsuit, it is not a case that lawsuit, we are not trying to comply with lawsuit. It is not a case that lawsuit.
No.
No, it is not a case. They are not. They cannot say that also.
Department.
Lawsuit?
Ask someone to remain present.
Yes.
Lawsuit, that part lawsuit may decide that day lawsuit, whether their presence is required or not. After lawsuit obtaining the.
No. You ask them to assist the court to remain present.
Lawsuit may indicate that part, otherwise.
Question.
For assist the court lawsuit.
Oh, yes.
That part lawsuit may indicate.
Yeah.
Indicate.
Registrar's presence may also be.
Register as well as somebody from the higher education.
Otherwise, lawsuit, the present incumbent is not made a party here lawsuit. Who will come here lawsuit?
Pardon?
Not present incumbent is not a party here lawsuit.
Who is the present
In
income?
this contempt petition, present income is not a party here lawsuit.
Now, how many substitution petition will
Not
file?
not a single substitution petition is filed in this case lawsuit. Not a single substitution petition. That's
It's a-
why we are trying, Lordship. Not
It's
a
a
single,
contempt case of
not a single
22.
substitution petition is filed in this case, Lordship.
Eh?
Not a single,
Affidavit কোনে file কৰিছে?
not a single substitution petition is filed, Lordship. That person, Mani Bandhan is Lordship, long back he was Lordship
কোনে file
from that service, from the department, Lordship.
মণিবনন মণিবনন হ্যাঁ It's a contempt petition of 22.
Let them implement, Lordship. Let them implement the present incumbent, Lordship. Let them implement the present
No, no.
incumbent, Lordship.
Anyone from the Directorate of Higher Secondary.
No,
Higher
higher education department.
Department.
That's why I'm saying, Lordship. He can implement the present incumbent, Lordship. Then he can, Lordship.
No, that is a different matter.
Lordship.
We-
No, otherwise,
we
if Lordship
want
after
his presence
presence,
or-
after presence of the particular persons, Lordship, if Lordship prima facie satisfied that some wrong was done, Lordship, then Lordship can proceed with the process, Lordship. That's why, Lordship, he can implement the present incumbent, Lordship.
No,
This is the
no.
procedure, Lordship.
No, right now we are not on that point. We
Otherwise,
are only to dispose of the matter.
dispose of the matter, for disposal of the matter, Lordship, Lordship, present incumbent is necessary, Lordship. Present incumbent is necessary, Lordship.
But first they ask someone to remain present. Not formally, informally ask them to remain present. One officer from the Higher Education Department.
One who is aware of the.
Yes.
That's why, Lordship, I am saying, Lordship, that person should be implemented,
That
Lordship.
will take care of later on if necessary. Or
Otherwise,
necessary.
that particular matter, Lordship, without implementing, Lordship, department is trying, Lordship. In every cases where, Lordship, the particular incumbent is not holding the office, Lordship,
No,
all
maybe,
the, Lordship.
that person may not be there, but the department is there.
Department is there, Lordship. I am not saying that
Therefore,
contempt is
let
against the
anyone from
particular
the
person,
depart-
Lordship.
let anyone from the
Contempt is
depart-
against the particular person, Lordship.
Okay, we will say you ask them to remain present. Third, Mr. Ken Chaudhary, learned senior counsel, assisted by Mr.
DJ Das.
Learned counsel for the petitioner, and Mr. Gogoi for respondent contender number 1. You are for 1. 1. Then Mr. Goswami for respondent number 2. Contender number 2. Mr. Gogoi learned is nothing else for the respondent number 1. Has produced a letter dated 5/5/2025 before this court, informing that there is a budget provision of 15,071.43 lakhs under the head of account 2202-03 102-3006 -000-31 CIA -99 -88 for the year 25-26, and out of the said budget provision, an amount of rupees 11,788.43 lakhs is allotted for regular salary. Number 2, rupees 1,687.00 lakhs for pension before work for 2013, and rupees 1,576.00 lakh for pension for those who have retired after 1/4/2013. 2013. And the amount due for the petitioners can be paid from the taking note of the submission of learned of both the parties, it is provided that the registered Dibrugarh University content number 2 shall remain personally present before the court on
Wednesday will be, I think, 14th.
14. Mr. Goswami, 14th will be convenient for your.
Yes, sir. 14.
14. 14. And any officer from the respondent number 1 department may also
My lord may indicate
Remain
from the
present.
office of the commissioner and secretary.
office of the
Commissioner and
Commissioner
secretary,
and
my lord may
secretary.
indicate.
Education
or
higher department.
Higher education department shall also remain present before the court to assist the court in disposing of this petition.
Lordship.
Deeply.
Lordship.
The letter produced before the court shall be part of the record.
Oblige.
For hearing item number 11.
There was a contempt under order, item number 27 of supplement.
Item 27.
Yes. Your Lordship, what earlier they had submitted a letter issued by the respondent contender. And your Lordship has asked the respondent to show as to whether there is any such provision in the act with regard to repeaters, that repeaters can be added in the total enrollment. And as such, there is no such provision.
In this regard, I have one instruction here. May I read, my lord?
So even if the statute does not provide for anything, so you can,
Yes, my lord. As per section 21.
as per
Section 20. Tableau 1, my lord. My lord, before that, my lord, I want to submit one thing, my lord. As per our instruction, here it is stated that for verification and scrutinize the enrollment data of Rajpur High School, the inspector of schools Kasar obtain a copy of attendance register of Rajpur High School of class 10 in the year 2015. Here it is enclosed, my lord. Upon verification, it is seen that the name of 33 students are reflected in the register, but most of the name of the students present in the register does not match with the names of the student present in the enrollment data provided by the petitioner in Annexure 10, my lord, of their additional affidavit, where the total enrollment during the year 2015 was shown as 35. Out of that, 23 regular and 12 is repeaters. And here, my lord, headmaster has written this to the inspector of school, and this is their register, attendance register. And attendance register and the annexure number 10, the name of enrollment are not matching at all. Both are mismatched. So here, probably two names is matching, otherwise most of the names are not matching with the enrollment, this enrollment student of the class 10. And moreover, my lord,
The
thereafter.
serial number is, different, but ultimately the total is 35, your lordship.
It is
Total-
also
total
written
is
by the
35.
headmaster, my lord.
Maybe in place of 24, the 26 names has been enlisted here. But the total, if you count, your lordship, it comes to 35. 35. In my additional affidavit, serial number 24, 26, and 35. It may be different in their record, but their names are there. Ultimately, total is 35. Maybe the names may be instead of 17, the name place 18 names has been placed in the serial number 15, maybe. But
No.
students' names are there.
Not all the students' name is Dear my lord, all are mismatched, my lord. Two, three students are matching, otherwise not matching.
No, they are,
Here, my lord, the total student enrolled is 33. But here, including repeaters, it is 35.
35.
32. 32, 31, 32, 33.
আৰু এটা দিছিলে নহয় তোমালোকৰ পৰা 32?
নাই, নাই, এইটো
নহয়, এটা চাই ল'বা। মোক I've been informed that they have sent 35 students. I've been informed.
Rajpur High School, class 10.
35 students are there.
And it is also
35 students are there.
from the letter of headmaster, it is stated that to the inspector of school, CDC Silchar, according to your requirement, I have sent a photocopy of the students' attendance register of class 10 of my school for the month of November 2015. It is to be noted that the student of class 10 of the year 2015 appeared in the SSLC examination in 2016. And these are the
So, prima facie, it appears that the requirement of, what is the requirement?
Requirement is 25. Requirement is 25. But they are trying to, your lordship, mislead this court, your lordship, because 2 pages they have sent. And there they have shown 1 page.
in the second paragraph. Also, as per Provincialization Act 2017, there is no statutory provision defining as to whether the repeaters should or should not be treated as fresh enrollment. The term enrollment has not been exhaustively defined in the Act itself. Therefore, as per practice procedure involved, at the time of consideration of provincialization of Vansar School, a report has been obtained from SEBA to ascertain the authenticate enrollment data of the school as the data collected from SEBA is authenticated and genuine and reliable.
No. Total, your lordship, 35. I have been informed they have a next single page. There is another page. I have been informed when the inspector came, I have been informed that they have sent 2 copies. They have served only 1 copy. Next, there is another copy showing 2 students' name, 34 and 35. That was not served.
So register may be called for.
Yes. And as per the act, your lordship will see.
All the names are not matching with that one.
Your lordship will see. On the first occasions, they have filed an order.
Mr. Sharma, this is contempt proceeding. We are not supposed to inquire all these
Yes.
things.
Yes.
So our concern is you have to comply with the order of this court.
Yes,
Now
yes.
options are available to you. You can
Yes.
opt for go to jail also.
So my lord,
It is up
here,
to you.
my lord,
Whether
SEBA's
you will
report,
comply with the order of the court or you choose to go to jail.
Total students, your lordship, 35.
my lord, sometime may be good.
But sometime. Even if it is not provided in the act itself, you have also find out another way to reject
Yes.
their prayer.
My lord, in the section itself, section 20 itself, it is it is stated that if any difficulty arises in interpretation of any provisions of the act, interpretation of the state government shall be deemed as final. My lord, page 125. Power of interpretation and removal of difficulties.
Interpretation.
But that option will not be available here. You have to comply with the order of the court.
Yes, yes. There is interpretation of any provision.
So had it been the writ petition, then the matter would have been different.
Yes.
This is a contempt matter, your lordship.
Having not filed any review petition or appeal, you cannot sit over the order of the court.
My lord, in compliance of that, my lord, order has been passed by the director, my lord. In compliance,
We are not
My lord,
concerned with what order your director has
my lord,
passed.
sometime may be granted, my lord.
What
I'll
sometime?
I
Two
will,
options are available. I have already given you the option to choose it. Choose.
They have placed one page. There was a two page.
You comply with the order of the court. Or remain present in the court on next day. This is not a writ petition to give a different interpretation to the words.
Yes.
Where you have got the authority to negate the order of the court. Tell me.
my lord, in compliance to that, my lord, order has been passed, my lord, here.
This order has been.
Heard Mr. P. Sharma, learned counsel for the petitioner. And also heard Mr. U. Sharma, learned standing counsel for the contender. After hearing learned advocates of both sides, the contender is given the last opportunity to comply with the order of this court. On or before
21st.
short date
Short date.
19th.
19. Or to remain present before the court personally on that day at 2 p.m. The letter produced before the court today shall be part of the record.
For hearing item number 11. Item 11 for hearing.
Non-appeal for the petitioner on call is the matter after 1 week. 2018 matter.
Item 20.
Other day, my lord. I'm seeking a little accommodation, my lord. Any other day. for you. These are completed, man.
Madam, you want to file object? No, sorry, reply.
No, Lordship.
No.
One reply we have already filed. The last affidavit was to bring into some documents into record. Last affidavit filed by them. Otherwise, we have filed a reply.
Part is A Talukdar, for the petitioner S. That for respondent number 2.
I'll be higher education, my lord.
Respondent in higher education department.
I'll be appearing for 1 and 2, my lord.
Respondent number 1. Mr. Das, thanks for listening the matter for admission hearing.
Yes, my lord. First week of June, my lord. Any. I'm sorry.
Acha, please.
My lord, in this case, my lord, my name was forwarded, my lord, for the in-charge principal. I am the most eligible candidate. But in spite of not giving me, my lord, they have given private respondent as well as my lord, inspector of school. So my lord, so far is my lord, academic in charge is concerned, my lord, they, last time they came with him, my lord, that already academic in charge has been given to me. But so far is my lord, financial is my lord, that is not been till today. They have not done it. And in fact, my lord, why they have not considered my case, my lord, that is not been disclosed to before this court till today. Last occasion, my lord, they have taken time. Nothing has been done, my lord, no affidavit, my lord. And if I am eligible for my lord post of in charge headmaster, and if I am, they have already given me the in charge of the my lord that academic in charge, then meaning thereby I am eligible for the in charge principal, my lord.
To that effect, my lord, I am praying for some more time, my lord, till next week to obtain the instruction, my lord. In fact, I've been told, my lord, there is some verification regarding his certificate, my lord. I'm not sure what verification is going on. So, my lord, may fix it on next week so that I can place the written instruction.
Verification.
Yes, my lord.
Or
Over telephoning, I have been
appointing him as insert headmaster.
no, my lord, regarding some certificate, my lord. regarding certificate. That is, my lord. Nothing else, my lord. Once the verification is done, my lord, I'll place it on next week, my lord.
My lord, already they have taken lots of time. One more week I can wait, my lord, no problem. But let them come with a concrete.
Exactly, my lord. That is why I'm
concrete instruction.
will place
Lord
it next
Mr.
next
T.J.
week.
Monto, learned senior counsel, assisted by Mr.
M. Islam.
M. Islam, learned counsel for the petitioner, and Mr. Khatonier for the respondent authorities. Mr. Khatonier submits that verification of certificate of the petitioner is being carried out by the respondent authorities, and he prays for granting some more time. There is not to obtain up to date instruction. There is allowed places a matter on
19 or 20?
29.
no 29.
29th May.
29.
Oh, sorry. 22nd.
22nd. Okay.
No,
22nd.
no problem.
Problem.